Yes, people, let's start our next chapter, compromise, arrangements and amalgamation. So in this chapter revision, what I'll be trying to emphasize on is one, yes, you guys know there has been some amendments, some topics have been removed. Good news for you. Next thing is that I'll try to keep it simple. I'll not be focusing much on the forms like we would have done in the class. I'll not be focusing on the forms. But let us try to focus on the procedure and everything else, yes, as it is. So, with that, let us start your compromise, arrangements and amalgamations. So, what is this compromise arrangement? Simple. Let us imagine we have taken a debt. There is a company A. The company A has taken a debt from SBI Bank and we are not able to repay. We have taken, say, for example, 100 crore loan and the company is not able to repay. Now, they want to enter into a negotiation. Yeah, like a settlement. Instead of 100 crore, is it okay if we give you, say for example, 70 crore? Would you be okay with it? Now, if SBI is okay with it, then yes, this particular thing will go through. If SBI is not okay with it, then compromise will not go through. Now, this process itself is called as people compromise, arrangements and amalgamations. So, whenever we are doing this chapter, what and all are the provisions that will apply? Which and all are the acts that will apply? Income Tax Act, yes. LODR, they can ask you a question here. Why is LODR applicable? Simple. Tomorrow when you are entering into any scheme of arrangement, if it's a listed company, it has to first apply to the stock exchange that, sir, we are entering into a scheme of arrangement. The stock exchange can give you either an letter called as observation letter or they will give you something called as no objection letter. Observation letter means there are some points that you need to first fix it. Next one is called as no objection letter. That means we are absolutely fine. And remember, the validity of the letter given by the stock exchange will be 6 months. So within 6 months, now you need to apply to the court or tribunal, wherever you are going for the arrangement, you need to, you need to apply to the tribunal along with the observation or the no objection letter given by the stock exchange. If you don't do it within the 6 months, you need to redo the process again. However, remember the no objection or this observation letter, this process is not applicable when, if at all you are merging with a holding company is merging with a wholly owned subsidiary company, then people, this no objection and all is not required. That is one thing. Sir, Indian Stamp Act, in short I'll tell you, what is that? Now whenever, let us imagine there are a merger between A and B. The company A is merging into company B. So this becomes a transferor company. This becomes a transferee company. Sir, now, whenever there is a merger, you need to apply for NCLT for sure. That is what is your 232. So now NCLT will give you an approval, correct? Yes. Now the question is, whatever is the order given by the court or the tribunal, now whenever any transfer happens or any transfers take place, now on the document, that document you need to pay stamp duty. Now for example, if I transfer my home, so on this instrument I need to pay a stamp duty around 6%. If the value of the home is, let us take for example as, say, imagine if it's 100 rupees, then 6 rupees will be the stamp duty. You need to pay to the government. Now the question is, if it is you selling to someone else, you need to pay stamp duty, okay. But if the court is passing an order that company A will merge into company B. Now we did not enter into any agreement. The court passed an order. Going forward, company A will merge into company B. Court passed an order. Now the question is, on the court's document, whatever is the instrument passed by the court, on that document should we pay stamp duty? There has been various judgments on this, but remember, this stamp duty is a state specific matter. Every state can have their own law. However, remember, there has been one case, Hindustan Lever versus State of Maharashtra. In this case, it was decided that even the order of the court is also considered as an instrument, and hence, even though there is a merger between two companies, because of the order of the court, it is still subjected to stamp duty. You need to pay the stamp duty. There are various other case laws. But what will prevail? Remember, there is an article called as Article 141 of Constitution of India. As per that, any order passed by Supreme Court will always bind on the lower courts. So accordingly, what has happened? To avoid confusions, some state governments also has made in their Stamp Duty Act, they have added you need to pay stamp duty for even the order of the court. The court's order is also included in the word instrument. So you need to pay tax by default. They have amended few states to avoid the confusion, like states like Karnataka, Rajasthan, Chhattisgarh, Madhya Pradesh, Gujarat, Maharashtra. All these people have changed their stamp duty and they have clearly put it in the act itself. Even on the order of the court, you need to pay stamp duty. If not, this is the judgment that will prevail. Clear, done. Next one, SEBI SAST, Competition Act, FEMA, Provision of Companies Act. Okay, next comes 230. Now, sir, let us take our case where there has been a application to enter into a compromise between the company and its creditors. Now, what is the procedure? First, an application will be filed by the applicant. Who can be an applicant? Applicant can be company, creditor, member. If the company is going for a winding up, in such case, liquidator can also file an application. Sir, why are we filing an application? It can be for entering into a compromise, arrangement, or even for takeover. What is the difference between merger and takeover? Merger means, people remember now, Vodafone and Idea merged. Vodafone came to an end, Idea came to an end. A new entity was created called as Vodafone Idea. This is called as merger. Takeover means what? Now, say for example, there has been an instance where Walmart has acquired Flipkart. It's a takeover. Now Walmart also continues, Flipkart also continues. That's the beauty of takeover. There is no entity that comes to an end. Okay, now they are filing an application with NCLT. Okay. Now, there is a compromise, arrangements or takeover between the company and it can be creditor, one person, or there are group of people, then it will be class of creditors. Member, one person, or class of members. So, we want to enter into a compromise. We file an application with NCLT. Okay. Now, along with the application, we also have to disclose certain things. What is that? All the material facts, that is financials, my audit report, any pending cases, investigations, whatever is there, we need to disclose everything. Scheme of corporate debt restructuring consented by 75% to the secured creditors in value, meaning this is the plan we are proposing. So the plan which is agreed by 75% to the creditors, I have to give an application. Protection for the other secured and unsecured creditors. So we give all these details, valuation report, what is the current state of the company, what is the value of per share. I'll give all the details. Okay. Now, once we file an application, what will NCLT do? NCLT will order to conduct a meeting for which notice of a meeting shall be sent to. So NCLT will say, okay, I understood you want to enter into a compromise. I am telling you, first you conduct a meeting. In that meeting, you call your shareholders if it is a compromise between them. If it's a compromise between the creditors, then call them and you first conduct a meeting. So we will call them and a notice will be sent to whom and all. A notice will be sent to all my creditors, my members, my debenture holders. Only them, sir. We will also send our notice to all the other authorities as well. What do I mean by authorities? Authorities means people, my central government, RBI, IT, your Competition Commission of India, stock exchanges, any sectoral regulators like IRDA or TRAI, We'll give application to every one of them. If they have any objection, please come and tell. Okay. So the representation, if any, to be made within 30 days. So if these authorities have any problem, they have to make a representation within 30 days. If there is no representation, it is assumed as no objection. Now we will conduct a meeting. Now these people are coming for a meeting. Now we will tell people this is what is our proposal. Now people, for a scheme to be approved, people remember it should be approved, consented by majority of person representing 3/4 in value. What do I mean by that? Let us imagine there are 10 creditors. For the meeting, for the proposal to be accepted, people, it should be first agreed by majority of person in number. That means in 10, what is majority? 6. 6 people have to agree. And that 6 people should be holding 3/4 in value. That means the total 10 people, the total money we owe them, let us imagine, is 1000 crores. 3/4 in value, 750 crore worth creditors have to agree. Hello. So both conditions have to be satisfied. Same thing applies even to the members as well. Hello? Clear? Okay. Now voting can be even done by person or even by proxy, or even you can conduct it by postal ballot. Sir, what if we want to object this? Can we object? Yes, possible. It depends upon who wants to object. If members wants to accept, then I object. That means members holding minimum 10% of the shareholding can come in value, can come and object. We are not okay with this. If it's creditors, then having minimum 5% of the total outstanding debt, they can come and object it. Okay. And remember, the tribunal may dispense with calling of a meeting. Look at the words, may. It's optional. If tribunal thinks, people, that whether we conduct the meeting or not, it is not going to make much difference. The tribunal may say, let us not conduct the meeting at all. Let us dispense the conducting of a meeting. That means the meeting itself will not be conducted. If the members, if minimum 90% of the creditors in value agree and confirm by affidavits to the compromise. That means what? Here, how many people agreed? 75%. No. Instead of 75%, if 90% of the people agreed for compromise, arrangement and amalgamation, in such case, the tribunal may say, it's okay, don't conduct the meeting, save some time. But remember, this is completely discretion on the NCLT. You cannot insist it. Generally, when will NCLT give it? Whenever NCLT feels that it is not going to create any harm to anyone, in such case, NCLT may dispense with the meeting. Clear? Hello, all of you? Okay. Such approved scheme shall be forwarded to NCLT, and what NCLT will pass an order. Whatever is the order passed by NCLT, we will also file it with ROC. Okay. Now NCLT can pass the following orders. What is that? If scheme is for converting preference shares into equity shares, then so imagine there was some members, right? We had preference shareholders. Now we are converting preference into equity. Now what about the outstanding preference dividend? You need to give an option to the shareholders whether do you want the preference dividend to be settled in money, or do you want to get equity shares even for that? You can choose. Next one, if there is any creditors, protection for them, that means they should be repaid. If scheme results in variation of shareholder rights, you need to follow section 48. What is 48? 3/4 of issued shares or special resolution. If variation of one shares affects other shareholders, you need to take the 3/4 of approval of them also. You need to follow that entire thing. The scheme is approved by creditors. Proceedings before BIFR shall stop. What is BIFR? Board for Industrial and Financial Reconstruction. This is off late. It is not existing, people. After IBC and all came, that has almost come to an end. Exit offer for the dissenting shareholders. Whoever is not agreeing, you have to give them an exit opportunity. You have to give them an opportunity to exit within 30 days. Whatever is the order passed by NCLT, that will be filed with ROC as well. Now that is section 230. Now tribunal has passed an order for you to enter into a compromise. Now the question is, whether are you entering into a compromise? Are you what do you say? Are you following that particular order as it is, or are you making any changes? They're telling you power of tribunal to enforce the compromise and arrangement. That means what? I have a right to supervise your entire compromise. At any given point of time, if NCLT gets to know that you are not following what was approved as per section 230, NCLT will try to make modifications to that particular compromise or arrangement. We will try to make modifications. If at all people it is not working and neither do you have money to repay that debt, creditors completely repay. If you are not able to follow the scheme, you are neither able to follow the scheme nor you are able to repay the debt. Remember, NCLT can pass an order for winding up your company. That also we can do. Hello, clear? Yes, sir. That is only section 231. Okay, next one, section 232. What is 232? Mergers and amalgamation of companies. Now, what is this? Where an application made under section 230 instead of compromise, if Vodafone Idea wants to come together, remember, then two sections will apply, section 230 as well as 232. Sir, what 230 will apply? 233 to 236 as it is will apply. What do you mean by that? We give an application to NCLT for merger. What will NCLT do? NCLT will tell you to conduct a meeting. In that meeting, people, we have to give a notice to our creditors, members, debenture holders, and also to all that authorities. Now I have to conduct a meeting. Now if they have a problem, they have to come and object. In the meeting, if at all the resolution is to be passed, it has to be agreed by majority number 3/4 in value. If they don't like, the 10%, 5% people can object. That 233 to 236 shall as it is apply even for this merger. Hello? Simple? Okay. In addition to the notice specified in 233, we send it to the debenture holders, creditors and members. We send a notice of the meeting, right? In that notice, we have to send some other details also, since if it's a merger. What? The draft of the proposed terms adopted by the merging company. So what will you get in return? Purchase consideration, etc. Confirmation of the draft scheme filed with ROC. You have to first file a scheme with ROC. Effect of compromise on shareholders, KMP, promoters, non-promoters. What will happen because of this merger? The valuation report, that is what is the value of the company, and supplementary accounting statements if any required. So if all of this is filed with the tribunal, and if tribunal is satisfied, the tribunal will the tribunal will pass the following order. What is that? In that order, he will make arrangements for all these things. What is that? First one, all the properties and liabilities, assets and liabilities from the day Vodafone and Idea, everything gets transferred to Vodafone Idea. An allotment of shares or debentures or other instruments by the transferee company. What is this? Nothing but purchase consideration. So you will get the shares. If anyone was a shareholder in Vodafone, you will get the shares in Vodafone Idea. Same thing. Sir, if any cases were pending in the name of Vodafone, it will continue in the name of Vodafone Idea. Next one, dissolution without winding up of transferor company. Once everything is transferred, Vodafone Idea comes to an end. The Vodafone Idea will continue. The transfer of employees, all the employees of Vodafone, all the employees of Idea will become the employees of Vodafone Idea. If transferor is a listed company, remember transferee is an unlisted company, it shall still continue to be unlisted. Remember, just because Vodafone is listed, Idea is listed, Vodafone Idea will not automatically become listed company. They have to file a separate application again to the stock exchange. Next one, exit option should be given to the dissenting shareholders. And remember, due to merger, if any increase in authorized capital happens, you need not pay any fees. Whatever is paid in the previous companies, that itself will be adjusted even in the new company. The fees paid, authorized capital. Such certified copy of the tribunal shall be filed with ROC as well within 30 days. Whatever tribunal gives, I have to file it with ROC. The scheme shall indicate an appointed date from when the scheme shall be effective. In the scheme, you have to clearly tell what is the effective date. Until the completion of scheme, every company shall file a statement given by a practicing chartered accountant, cost accountant, or a company secretary every year until that entire scheme is completed. Meaning, people, what is the status? Is it completed? Is it half completed? What is the status? You have to keep on giving this particular the order, that is a statement which is signed by a PCA, PCS, or a PCMA. I hope it's still audible, da? Yes? Okay. Oh, this is so much comfortable, da? Without, with mic. Yep. Okay, people, the next section is section 233. In 233, there is some amendments. What is 233? 233 was nothing but a fast track merger. Fast track merger can happen between whom? A fast track merger could happen between small companies, two or more small companies, a holding company, and look at this, wholly owned subsidiary, and any other company as may be prescribed, that is between two startups or startup and small company. This is what was previous, correct? Now there is an amendment here. They have added something else also. Now what is that? They say that, again, now see here, this is an updated list. Exam point of view, important, concentrate. The central government has prescribed the class of companies between which a scheme of merger or amalgamation may be entered. Who was that? Two or more startup companies, which was there. Startup and small, already there. Now this is an amendment. One or more unlisted company, which is not a Section 8 company. So Section 8 companies, this rule will not apply. With one or more unlisted companies not being a Section 8 company, where every company involved in the merger has in aggregate outstanding loans, debentures, deposits not exceeding 200 crores and has no default in repayment of loans, debentures, or deposits referred to in subclause A on a day not more than 30 days before the date of notice referred to in clause A or subsection 1 to 33 of the Act on the date of filing of scheme under sections of the 2 Act of the Act. What is this, sir? Technically, people, imagine if there are two unlisted companies that they want to merge. Imagine unlisted company X, unlisted company Y. They both want to merge. And both of it should not be a Section 8 company. They both can merge. They're telling you they need not have to, they need not have to go under 232. Earlier, they should directly go under 232. Now they're telling they can come under 233 only, it seems. They need not go under 232. Direct 233 is possible, provided. What they are telling you is that two unlisted companies can come together. They should not be a Section 8 company, provided those two unlisted companies should have their aggregate of loans, debentures, deposits, put everything put together. It should not exceed 200 crores. That is company X, company Y, aggregate loans, meaning add everything. It should not be more than 200 crores. And second thing, both have to be satisfied. There should not be any default in repayment of loans, debentures, and deposits. Whatever I have mentioned here, there should not be any default when on a day not more than 30 days before the date of notice. Meaning, whenever you are going into this amalgamation, you will give a notice, right? 30 days before that, there should not be any default. So before that, clean off everything. You're good to go and enter into a merger under fast track. That is what they're telling. Here, you should not have more than 200 crore. Next one, there should not be any default. That too, when before you issue a notice, 30 days prior to that, you should have not have any default. Okay. That's all. We have more here. Provided that a certificate from the auditor of the company that the company meets the conditions referred to in this clause shall be filed in form CAA 10A along with a copy of the approved scheme. So CAA 10A, the auditor have to certify, and we will sign this with the company's meeting. Whenever we are filing the application, we'll be doing it along with this. Okay, and who else, sir? Who else can come under fast track merger? They're telling a holding company which can be listed or unlisted, a holding company and a subsidiary company, listed or unlisted, can come into a merger provided that this clause shall not apply where the transferor company or companies are listed. Now, what do I mean by that, sir? A holding company and a subsidiary company, they can enter into a merger. It's possible, provided this clause shall not apply where the transferor company are listed. That means what, people? Company A is selling all its shares to company B. Imagine it's like a takeover. Company A is selling everything, company B is acquiring. What will we call company A as? We call it as transferor. What will we call company B as? We call company B as transferee. That telling the company B can be either a holding company, the company B either can be a subsidiary company. Both of it is possible. You can be a holding company also, you can be a subsidiary company also. Transferee company can be a holding company or a subsidiary company, but transferor company cannot be a listed company. This is not possible. The transferee company can be a holding or subsidiary. Now, this can be a listed company. That is absolutely fine. You can be listed or unlisted. Sir, this holding company, subsidiary company, already it was there. No, I told you to remember the letter. Earlier it was holding and wholly owned subsidiary. Now they have said holding and subsidiary company. That's the difference. Clear? And transferor should never be listed. That's the new thing that has been added. Okay. So they can enter into a fast track. Next one. One or more subsidiary company of a holding company with one or more other subsidiary company of the same holding company where the transfer company or companies are not listed. Same thing. What is happening? There is a holding company. The holding company has a subsidiary company called as subsidiary 1. The holding company has one more subsidiary company that is called as subsidiary 2. They're telling subsidiary 1 and subsidiary 2, they can enter into a fast track merger possible, provided whichever is the transferor company, they cannot be listed. This is not possible. Transferee can be listed or unlisted, it's absolutely fine. I hope this is clear, all of you. Yeah, that is a new amendment. Remember, exam point of view, very important. Clear? Yeah. Okay. Now come back. The procedure is same. Every company, transferor plus transferee, shall formulate a scheme. Such scheme shall be sent to ROC, liquidator of both the companies, and to the person who shall be affected by the scheme. Whoever will be affected by the scheme, we will send this list to everyone. Okay. Now, why are we sending them? For inviting objections or suggestions. Such suggestions or objections are considered by the company in general meeting, and such a scheme shall be approved by. So, if the scheme has to be approved, fast track merger, members holding 90% of total number of shares and majority representing 9/10 in value of creditors. So, members holding 90%, technically both are 90% only, no? They have to agree for this particular merger. Such approved scheme shall be filed by the transferee company with the ROC and liquidator, and we will also file it with the central government. So first of all, what will we do, people? First we will take up the scheme. Already scheme is there. That scheme we are filing it with the ROC, with the liquidator, and with any other person concerned. Then we will conduct a meeting. Now in that meeting, people, they're telling you we have to take the approval of 90% of creditors and members. Such approved scheme we will file it with again ROC and liquidator, and we will give a copy to the central government as well. Now, what will ROC and liquidator do? If they think they have any problem, if they think they have any objection, they have to file their objection within 30 days. They will file it with the central government. Now, what will central government do? If at all, imagine there is no objections, within 30 days they did not file anything, the central government will give a clearance. CG shall register and he will issue a confirmation to the company. That confirmation we have to file it with ROC. Sir, what if there was any objection? If at all there was any objection, the CG is also with the opinion that such scheme is not in the interest of the creditors or public interest. That means ROC and liquidator said no, it's not right. And CG is also satisfied. Yes, it is not in the interest of the public. In such case, what will the CG do? CG will forward the application to the tribunal and they will say, please take this up in a usual 232 way. This company cannot come under 233, that is fast track merger. He will send it to 232. So the matter will be taken up as 232, that is your regular merger, not as fast track merger. The registered scheme shall transfer the properties and liabilities, that is if it is going through, it ends up in a merger, all the assets and all will be transferred. Charges shall continue in the new company's name. Whoever are not okay, we have to give them exit opportunity. Any legal proceedings, cases will continue in the new company's name. Any authorized capital fees paid will be adjusted in the new name. Again, you need not pay. The company can, this is also important, remember. Sir, it is the company's discretion. If they want, they can file under 232, or if they want, they can file under 233. For example, you just saw a holding company and a subsidiary company. They want to enter into a merger. If they want, they can go under 232. If not, they can come under 233. They have complete choice. Sir, why is that so? Remember people, what if they don't get this 90% approval? So this 233 is not possible at all. So if I say you have to go only under 233, in 233 if I don't get that approval, they should at least be able to go under 232 with the majority or whatever is the approval as per 232. If I just am able to satisfy that procedure, I should be able to enter into a merger. You can't stop me forever. Correct? That is section 233. Okay. Next one, section 234. In short, I'll tell you, can an Indian company and a foreign company enter into a merger? Absolutely fine. You can enter into a merger. Only thing they are telling you is people, same 232 only you will follow. In addition to that, people, you will also take RBI approval or any other approvals that are required. For example, CCI, Competition Commission of India. Of course, for every other merger also we need to take. It's not like only for 234 we need to take. For every other merger also we need to take. But in addition, yes, RPI approval becomes mandatory if there is any merger between Indian company and foreign company. That is what is section 234. Yes, sir. Both the companies shall obtain prior approval of RBI. The transferee Indian company shall comply with provision of 233. The application shall be made by the transferee Indian company under 233. What is this? Where the transferor foreign company incorporated outside India, if it's a holding company, and the transferee Indian company being a wholly owned subsidiary company incorporated in India, if they want to enter into a merger and amalgamation, then both have to take RBI approval. The transferee Indian company has to comply with 233. The application shall be made by transferee Indian company to central government under 233, and the provision. What is people? Nothing but fast track merger. They are telling you it is still possible, it seems, for a holding company and a wholly owned subsidiary. If a holding company is from India and if wholly owned subsidiary, this is from foreign country and if this is from Indian country, they're telling it is still possible. How? RBI approval plus I need to follow section 233 allowed. That is what they're telling you. That is my 233. Okay, next one, sir. 234 is done. 235. What is 235? Power to acquire shares of dissenting shareholders from the scheme. Contract approved by majority. What is it, sir? Let us imagine, people. We have given one, what do you say? Company A wants to acquire company B. We have given a proposal. And in company B, we got the majority approval. That is, we are okay to sell our shares to company A. Then whoever are left, whoever are not accepting, now they are called as dissenting shareholders. 235 says whoever has not acquired for the acquisition, you will give them a second opportunity. You will ask them, people, we really want to buy you out. Are you interested to sell your shares? We'll give them a second option. So whoever are the remaining shareholders in company B, they will be given another choice. Now they will be covered under section 235. What is the procedure? See here. If there is a scheme involving transfer of shares in a company, plus it is approved by majority. That too, majority means what? Not 75% or 51%. Holders of 9/10 in value, 90% of B company shareholders have already transferred, 10% are remaining. In such case, what they are telling you, if that 9/10 approval is to be received in 4 months of making of the offer, shares already held by transferee company shall not be counted. What do I mean by that? Company A gave an offer to company B shareholders. We want to acquire you. And company B shareholders, 90% of the people gave us their approval. That too within how many days? Within 4 months of the day I made an offer. Within 4 months, if 90% of the approval if we got, then they are telling you, people, that the company A will again send one more offer to company B. Sir, what if within 4 months, if I did not get 90, imagine we got only 80, then this section will not come into the picture at all. If within 4 months, if you did not get 90%, section 235 will not apply at all. So let us assume we received 9/10 within 4 months. Then within 2 months, after the 4 months, the transferee company shall send notice to acquire shares of the dissenting shareholders. Company A will send one more notice to the rest of the 10% people within 2 months. So 4 is done. After that, I will be given 2 months time. Within 2 months, I will send another notice. Now, within 1 month of the transferee company giving notice, I gave you the notice, no. Within 1 month, if at all the 10% people, if they are not interested to sell, they can appeal for the tribunal. Sir, we don't want to sell it. So please don't force it. Now people, the tribunal may pass such order as it may deem fit. What is that? If the tribunal passes it in the favor of dissenting shareholders, then the acquisition comes to an end. They will acquire 90% and they will move on. They will not touch the rest of the 10%. Okay. So transferee company shall not acquire the shares. Sir, what if they say, no, we will give the order in the favor of transferee company. Then people, in such case, the transferee company is entitled and bound to acquire those shares on the terms of approving shareholders. Meaning, whatever terms we acquire the 90% of the shares, in the same terms we will also acquire this 10% of the shares. That's what they're telling. Clear? Yes, sir. So within 4 months, if we do not get the 9/10, then people, the scheme will come to an end. Remember, what is the procedure? The transferee company will first send a notice. Along with that, you will also send the instrument of transfer. The transfer on behalf of dissenting shareholders shall be executed by a person appointed by the transferee company. So someone will take care of all the procedural requirement. A separate bank account shall be opened to keep the money or consideration received from transferee company and shall be paid to and it shall be paid to the shareholders within 60 days. So whatever is the purchase consideration, A will give to the shareholders of B, right? Now this money has to be settled within 60 days is what they are telling. And they will, until it is settled, it will be separately deposited in a bank account. The transferor company shall register the transferee company as the holder of those shares and within 1 month from the registration intimate the dissenting shareholders about such transfer and consideration. So within 1 month we will register everything and will intimate the dissenting shareholders also. People, all of this has happened. What do you want to do? You guys only decide. Okay. That is section 235. So next one is section 236. It is called as purchase of minority shareholders. Now remember people, most of you will get confused between what is the difference between 235 and 236. First of all, what is the difference? Try to understand. 235 will come into picture only when there is one company trying to acquire another company. So there is always a transfer request that is made. 236, that is not the case. Then let us imagine there is one shareholder who is holding, let us imagine, 80% of the shares of the company. Plus, this person also has some convertible debentures in the company. Rest of the 20% of the shares in the company were held by other public. Now, after 5 years, what happened? This convertible debentures got converted. The debentures got converted to equity, which made him the owner of 80 plus 10%. The debentures got converted to equity. So he ended up getting 10% of equity shares. He has not made any request for transfer, nothing, but he became a shareholder for majority of the shareholding. That is 90% of the share, he became a shareholder. Now people, he will make an application to this rest of the people. Why? Because mine became 90. Now this will also reduce. Yeah. So because of that, what happens? Let us imagine the proportion became 90 and 10. Now what will I do? I will make an application to this 10% of the people saying that people, I am interested to buy your share also. Can you sell it to me? Sir, this is the first case. Here there is no transfer. Here you become majority shareholder in some or the other way. I just give you an example. Are you getting the point? Now sir, let us imagine whenever there is this, what do you say, a person becoming a shareholder of majority. Now the law says you need to give an application to the rest of the 10% holders also that you are interested to acquire them. Sir, what if they are not interested to sell? Can they still go for tribunal? Remember, in 235 you can go for tribunal. In 236 you cannot go for tribunal. In 236 you don't have a right at all. You have to sell your shares and you have to go. You don't have a choice in 236. That's the biggest difference. Yeah, remember. When acquirer or person acting in concert or any person or group of person, if they become registered holder of 90% or more of this is the third difference. In the previous, it was 9/10 in value of shares. On paid up value it is. Here it is based on issued capital, not on paid up capital. So you become a shareholder of 90%. It can be because of amalgamation, share exchange, conversion, however it is, you become a shareholder. Then he shall notify the company its intention to buy the remaining equity shares. The minority shareholders may offer to the majority shareholders as well. If you want, you also sell it and you go. That is also possible. The majority shareholders shall deposit the money. So the 90% of the person, he has to deposit the money in a separate bank account to be opened by the transfer company, and same should be disbursed to entitled shareholders within 60 days. So it has to be paid within 60 days, whatever is the money to be settled. Okay, next one. Sir, if not possible within 60 days, the disbursement can continue for 1 year. If when any shareholder who have died or ceased to exist, or whose heir, successor or administrators who have not been brought on record by transmission, right to offer in such case shall continue for 3 years from the date of majority acquisition. What do you mean by that, people? They are telling, imagine if at all a person is there on the record, if I am able to pay them, I have to make the payment within 60 days. Within 60 days, if I am not able to pay, they're telling it's okay, you can pay up to 1 year. Whenever I think that the shareholder have died or something like that, they're telling, if at all because of transmission, if I have not got the person on record yet, I can continue to make the payment even up to 3 years, because we have not registered the person, so we don't know who the person is yet. There is a death, so we do not know who the exact shareholder is. In such case, they are telling you people, you can even continue to pay up to 3 years as well. The consideration, it's okay. Next one. The transferor. So see, I hope this one you guys understood. Within 60 days, if I don't pay, I can continue to pay even up to 1 year. That is okay. Right to offer in such case shall continue for 3 years from the date of majority acquisition. What do you mean by that? The majority people will be liable to acquire these minority shares even up to 3 years. Even within 3 years, the minority people never came. That means die, that's all. You don't have a choice. So the maximum time we will accept is people up to 3 years. So until 3 years, the majority shareholder will still be liable. The transferor company shall act as transfer agent between majority and minority. So in between them, the transfer company will gap the bridge. If the minority fails to deliver the share, so in 235, what happened? They went for tribunal. Here, what if we don't deliver? You can't do anything. The company will allot a duplicate share certificate on your behalf, and they will only sign and they will only transfer. If it is in demat shares, so they will just intimate, they will pass an order. You cannot hold it. As per section 236, you have to mandatorily sell your shares to me, and they will just transfer the shares automatically. They will issue an instruction to your demat account, and they will debit the shares from your account. It will be credited to that particular majority shareholder. Yes, next one. Sharing of additional compensation. If shareholders holding 75% or more minority equity shareholding negotiate for higher price for any transfer than what is proposed or agreed upon without disclosing such fact, such a majority shareholder shall have the additional compensation with such minority shareholders on a pro rata basis. What do I mean by that? Sir, let us imagine 90% of the shares was given to the majority. He became majority shareholder. Because of conversion or anything, he became a shareholder. Now what happened? In the 10% also, let us imagine there are, let us imagine 5 shareholders. Let us imagine. Now these 2 shareholders, they hold around, out of this 10%, they hold 8%. These 3 people hold 2%. That means what? In this 10%, they are holding 80. In this 10%, they are holding 20%. Correct? What they are telling you, if shareholders holding 75% or more in the minority equity holding, that is these people. Now what will they do? They will go and negotiate with majority shareholders that, see, You are offering 230, right, for them. But we will sell only if you give us 280. If not, we will not even give you one share. The majority shareholders were like, okay, they agreed to give them 280, but for them they got 230 only. The law is telling these majority shareholders, whoever got extra 50 rupees, they need to share it with the minority shareholders. That is what they are telling you. So if the majority shareholders in the minority, if they are getting any excess purchase consideration, they have to share it with the minority shareholders. That is what they are trying to tell you. Is this clear? Okay, that is your 236. Next one is 237. What is this? Power of central government to provide for amalgamation of companies in public interest. What do you mean by that? If I think, people, that in the interest of public, we have to merge two companies, if I think so, it is in the good interest of the public, what do I do? If CG is satisfied, it is essential in the public interest that two or more companies should amalgamate into one company. Central government may do it by notifying in the official gazette, and legal proceedings shall continue in the transferee's name. Imagine there is company X, company Y. If central government thinks it is in the interest of the public, they can merge this into XY. Whatever is the cases, it will continue in the XY's name. Why do we do it? It is in the interest of public, for the purpose of public. Now, for example, I can tell you, the State Bank of Travancore, State Bank of Hyderabad, State Bank of Mysore, all of this was losing its edge. They were not doing that great. So to retain them, central government has to do something. What can they do? They can say all of you will going forward merge with SBI to make this a bigger bank. So in the interest of public, to protect it, if at all central government wants, they can pass such order possible. Okay. Every member, creditor, debenture holder shall have as nearly as possible same interest or right in the transferee company. Whatever was my shareholding here, I should have as much as possible the same shareholding in the new company as well. So imagine if I was a shareholder in State Bank of Mysore. In State Bank of India, I should hold a similar percentage. Sir, what if I am not holding similar percentage? Then people, you need to settle them. Whatever is the compensation, you need to pay them. In case of any variation, he shall be entitled for compensation as assessed by such authority, which shall also be disclosed in the official gazette. Sir, what if I am not happy with the compensation they are paying? Then can I do anything? The answer is yes. Any person aggrieved by assessment of such compensation within 30 days of publication, he may make an appeal to the tribunal. Before passing an order under this section, the following requirements are fulfilled. What is this? Draft order. How do I make an order, sir? How will central government make an order? First one, I'll have to come up with an order. The central government has made modification to the order based on suggestions within 2 months. If at all any suggestions are given, the central government should have made the modifications. The time is expired for appeal. Every order shall be laid before each house of parliament. So central government is giving an official gazette notification, right, that about the merger. So any order passed under this section, first it has to be laid in front of both the houses of parliament. Remember. Yes, that is 237. What is 238, sir? 238 is nothing but people. It actually has to be read with section 235. What is 235? 235 is nothing but whenever you saw here, right, a company A is acquiring company B. There is a transfer of shares involved. Before you give any order or any notice to the company B, you have to first show that notice to ROC. That is what is section 238. Every offer of a scheme or contract involving transfer of share under section 235, such a circular containing offer and recommendation to the members of by directors shall be first communicated by information prescribed in Rule 28 in CAA 15. Such offer shall contain statement on behalf of transferring company disclosing steps taken to ensure cash availability. Every such circular shall be presented to the registrar for registration, and circular shall not be issued until registered. If ROC refuses, company can appeal it to the tribunal. What is this, sir? Now, what they're telling you is, before, imagine, company A wants to acquire company B. Before you give any notice to company B here, I need to first give it to ROC. ROC, if he approves, then people you can give it to company B. Sir, what if ROC does not approve? Then company A definitely has a right to appeal in the tribunal. You can go to the tribunal. That's all. That is section 238. So any offer given to the company B, before giving, they have to first intimate it, notice to ROC. If you are not happy with ROC's outcome, then you can always go for an appeal. Done. That's all. That is 238. Next one, sir. 239 and 240. Children sections. What does 239 say? 239, preservation of books and papers of amalgamated companies. What do you mean by that? So whatever the companies that came together, now company A, company B came together. Now company A, once it is merged, can I destroy all the books of company A? They're telling you no. If you want to destroy any books of the amalgamated companies, you have to take first the prior approval of central government. That is what is the section 239. You cannot destroy any books without prior approval of central government. 240 is nothing but people, whatever are the liabilities that, imagine a director has done some non-compliance in the old company. All the liabilities will continue even after the merger on the company or on the directors, as the case may be. The liabilities will still continue. It will not come to an end. Simple. Okay, next one, people, majority versus minority. What is this? We have seen a case called as Foss versus Harbottle. What happened in this case? In the case of Foss versus Harbottle, there were two shareholders. Their name was called Foss and Turton. They brought an action against the directors and solicitors, that is like an advocate of the company, alleging that by their concerted and illegal transaction, they had caused the company's property to be lost. Two shareholders come and they filed a case on the directors and the advocate of the company that they have not been doing a good job. Because of them, almost all the reserves or money in the company has absolutely gone. Yeah? Okay. It was also alleged that there was no qualified board. Foss and Turton claimed damages to be paid by the defendants to the company. So they said, because of all of this, you guys have to pay us some damages, it seems. What is this damage? What is this? Something is bothering them. Some insect. Okay. It was held by the court that action could not be. I hope you guys understood, people. Two shareholders are filing a case on the directors and the advocate that they have not been carrying on the activities in a proper interest. In this case, what was decided, people? The court said one thing. Macha, remember that you two people cannot come and say that the company is not conducting its activities properly and all. If at all any problem is there, then always remember, you should tell the company only to come and complain. Sir, how will company come and complain? When I say company, company is always led by majority. So if majority people are okay with what the directors have been doing, then the minorities do not have a choice. They don't have nothing to say. You just have to see what they are doing. That's all. You don't have a choice. This was the case in 1956 Act, people. It is not in 2013. Today, in various sections, we have given a right under Companies Act 2013 only. The 10% rule. We just saw, no, even now also, 236 minority only, right? Variation of shareholder rights. It can be EGM. In general meeting, so how many places you will see? That is what they're telling you. Earlier, yes. Why did we follow this rule? Because if I allow the minority to file a case, imagine these two people going for what will happen, people. In a company, there will be 10,000, 20,000 shareholders. Is it possible for the directors to satisfy everyone's need here? Definitely not possible. So what will happen? I'll have to start. I'll have to start listening to everyone. I can't satisfy everyone, no people. How is it possible? So you have to go with majority. So to eliminate the futile cases, meaning what? Unnecessary cases. We do not want to take up more. We do not want to waste court's time. So they said the majority shareholders, when they are not acting, minority shareholders really cannot do anything about it. But with time, this particular thing changed. Exactly, especially in India. See, there are cases, especially this. In the case of ICICI Bank, ICICI versus Parsaram Puriya Synthetic Limited. In this case, what happened? There was a bank, ICICI had given loan to a company, and they also had some minority shares in the company. They wanted to file some case on this particular company. So the company said, hey, you are a minority, you can't really challenge anything. But Delhi High Court said, even though they might be a minority, but they have given you a huge loan, and the financial institutions play a very major role in money lending of the company. You cannot say they don't have any right. They do have a right. Even though if they are minority shareholders, they were given right. Yes, there is one more case law, Rajamandri Electric Supply versus Nageshwar Rao. In this case, what did they say? See here, if the directors are supported by the majority of the shareholders in what they do, the minority shareholders can in general do nothing about it. So you can't do anything. So this is Foss versus Habotel supported majority, Rajamandri supported majority, ICICI supported minority. Now today's date, what is the thing? Today's date, we have common law, meaning injustice means you can always go and fight in the court. Next one is Companies Act. In Companies Act, you can definitely go and fight. Earlier you had class action suit and all, which is officially deleted from our syllabus. What are the contents that is deleted? All this is deleted. Pause for a while and see, everything is deleted. So if you guys have old books and all, make sure you don't read any of it. Rest of it is there. Is this clear, all of you? Pakka? I hope this is clear. Done? Yeah, so all these are removed. Clear? So that's your chapter 10. I hope this is clear. Okay, let's start the next chapter, that is Dormant Company. Easiest now, you guys have to literally by heart letter by letter in Dormant Company. You should not even leave one letter go from this particular chapter. Yeah. Okay, section 455 says what? What is the definition of dormant company? A dormant company generally means what, people? An inactive company. A company currently which has no business operations, but in the future it will have some business operations. Such type of company we generally term it as dormant company. A definition: they say a company where a company is formed and registered for a future project. Currently, as on today, we don't have any object. We are not carrying on any business today. We are as on today inactive. But after 1 year, we may get some business order. Currently, we don't have anything. So what to do? Let us at least enjoy some exemptions given under the law. So apply for dormant status and just sit. Or a company which is formed to hold an asset or intellectual property. So you have it, you apply for it, and you just hold it. You don't do anything else. So you imagine you apply for a trademark and you have the trademark and you keep it. You wait for the right moment to start the business. And the company should not have any significant accounting transaction. What do I mean by significant accounting transaction? It means a transaction other than these four. These four are not considered as significant accounting transaction. Anything other than these four are considered as significant accounting transaction. What are these transactions? Any payment made to ROC as the filing fees. So imagine if at all you are filing any form PAS3, if you are filing form DIR12, all of this is considered as what? All of this I need to pay some filing fees to ROC. That is okay. It is not considered as a significant accounting transaction. If you are spending for anything else, imagine payments made for your employees, payments made to acquire some plant and machinery today. Now all this will make it a significant accounting transaction. Other than these are significant, these are not significant. Next one. Payment made by company to fulfill requirement of this act or any other law. Imagine people, if you are making any payment for any licenses, permits, trademark act, you need to make some payment. It is not considered as a significant accounting transaction. For example, I need to file form PAS3. I don't know how to file it. I have asked for the, I have asked for the services of any professional. I need to pay him, right? Now I can't say that as a significant accounting transaction. It's not a significant accounting transaction. Next one, allotment of shares to fulfill requirement of this act. Remember people, if you're allotting any shares, it is not considered a significant accounting transaction. Remember, even though you are a dormant company, you still have to file form PAS3 and appointment of directors. You can still make these two and you still have to file the consent forms. It is still required. Any payments made, not SAT. Maintenance of office and records like rent, electricity bills, these are allowed. It is not considered as significant accounting transaction. So which other company is considered as dormant? Third one is called as inactive company. What do I mean by inactive company? It is a status of a company because of not carrying on any business or operation. So I'm not carrying on any business or not made any significant accounting transaction in the last 2 previous years. So we have incorporated, we don't have business. In the last 2 years, we have not made any big transactions or I have not filed my financial statements or annual returns for a period of 2 financial years. I think there is something missed. So I have not filed my financial statements or annual returns for 2 financial years. Now such companies are called as what people? Inactive companies. Now they can also apply for dormant status. Definition important, remember and go. Next one, compliances to be followed by dormant company. Even though you are a dormant company, there are some compliances you still have to follow. What is that? It shall have minimum number of directors as per the law. That is, if you are a private company 2, public company 3, OPC 1, these things you need to still continue to follow. The public company, private company, OPC can still file DSC. The dormant status, that is absolutely fine. Return of dormant company to be filed annually in the form MSC3 indicating financial position duly audited by a chartered accountant. What do I mean by that? Now imagine this year, in the year 26-27, we have applied for dormant status. Now what is the guarantee that the next year also you are still dormant? What if you have started doing business, you have started earning money, or if you have spent some money, then you are not dormant because you have done a significant accounting transaction. If you have made a significant accounting transaction, then how can you be a dormant status? You cannot be a dormant status. That's why every year you need to file within 30 days of the end of the financial year, you need to file something called as a return of dormant status in the form MSC3. This has to be certified by a chartered accountant because someone has to say no that yes, there were no transactions. I still have to do that. Next one, I need to conduct at least one board meeting in each half of the calendar year in such a way that the gap between 2 meetings should not be less than 90 days. So if you conduct one meeting in say for example June, the next meeting cannot be in July. So the gap should not be less than 30 days. Minimum gap should be 90 days. The company shall file return to ROC in case of Change in directors, allotment of securities. As I told you, DIR 12 and PAS 3 both are still to be, you guys still have to file it. It is mandatory. Remember. Application for dormant status, how do we get it? You can get it one by on its own when you apply for it. Next one, when ROC itself allots you. When will ROC allot you? If company has not filed financial statements or annual returns for 2 consecutive financial years, the ROC will give you a notice, and if it is convinced, then ROC may enter your name into register of dormant companies. It's may, people, not mandatory. ROC may. Next one, voluntary. When company itself wants, it can apply for dormant status. When is that? How is that? First is, the company will conduct a board meeting and approve the resolution, and it will call for a general meeting. Pass a board resolution, call for a general meeting. Obtain statement of affairs from a chartered accountant, because you need a nil balance sheet. If you have any transactions, you cannot apply for dormant. Conduct a general meeting and you need to pass a special resolution. Next one, because you have passed a special resolution, you have to file form MGT 14. Within 30 days of filing MGT 14, I need to file something called as MSC1. That is the form which is filed for applying dormant status. Along with MSC1, I need to attach something called as copy of special resolution, copy of statement of affairs, declaration by directors, other necessary documents. Next one, so I need to file all of that. On ROC being satisfied, the ROC will grant you something called as dormant status. Inform MSC 2, that's the reply given by ROC. What are the grounds considered by ROC to consider a company as dormant? What are the grounds considered? The first ground, there should not be any inspection, inquiry, investigation pending against the company. Prosecution is pending against the company. What do I mean by that? There is some case going on, there is some hearing going on. You cannot apply for a dormant status. If you have taken any public deposits and if those deposits are outstanding, section 76, you cannot apply for dormant. Or if you have made any default in repayment, you cannot apply for dormant. Next one, if there is any loan that you have taken, you cannot apply for dormant. Can apply for getting an NOC. Now, what is this outstanding loan? There is one point that we need to know here. What is that? With regards to the loan, the loan can be of two types. One is secured and one is unsecured. With regards to there are outstanding loans, whether secured or unsecured, we cannot apply for dormant status. However, if company has any outstanding unsecured loan, then the company may apply for the status of dormant only after obtaining NOC from the lender. That means what? If you have secured loan, people, then it is not possible at all. So if you have a secured loan, not possible. What if you have a unsecured loan? Unsecured loan, you have to apply with the creditor for the approval. If creditor gives you an NOC, people, then yes, you can do it. Remember this. Yeah. Next one, there should be no dispute in the management today. Now you need not have to attach to all of this in MSc when this is not required. No dispute in management or ownership supported by certificate. You should not have any disputes. A listed company cannot be given a dormant status. Default in paying workman dues, statutory payments or your PFs as the case may be. Outstanding taxes, duties to state government or central government. Any you need to pay any fees, any electricity bills, tax, GST, IGST and all? No. A company can remain dormant for maximum 5 years. After that, if you don't convert yourself, the maximum a company can remain dormant is 5 years. You cannot sleep forever, Noda. There is always a difference between rest for peace and rest in peace. You can rest for peace for some time. You cannot rest for peace forever. That time it will become rest in peace. That's what they are also trying to tell you. If at all you are applying for dormant status, the maximum you can be dormant for is only 5 years. Beyond that, people, you will become You have to convert yourself into active. If you don't convert, then it is one of the ground for strike off. Failure to apply for active status, it will be struck off from the ROC. Remember. Next one, company seeking status of active company. A dormant company can voluntarily, they need to convert. No, they can convert. How? You can file form MSc 4. Along with that, you also have to file form MSc 3, return of dormant company. I'll file it with ROC. Now, ROC shall change the status of active company and he will issue a certificate of active status in form MSc 5. What are the mandatory active status? If company has violated conditions mentioned in the grounds, directors should within 7 days seek active status. On inquiry by ROC, it believes company has been active, the company shall be converted to active. What is this, people? Imagine when you filed dormant status, that time you said no inquiry, investigation, or there is no prosecution. But what if after applying for dormant status, if something starts? You have to seek active status within 7 days. That is what they are telling you. Kiera, hello. Yes, that's your dormant status. Congratulations, chapter 12 is deleted. Nothing to worry. Complete chapter is gone. Yeah, happy, huh? Headache chapter it was, huh? Okay, let's start with the next chapter. Chapter 13, general meetings. Okay, so first things, general meeting. What are the two types of general meeting there? One is AGM, one is EGM. AGM conducted at least once in a year, annual general meeting. It is conducted within, what is it? General meetings, people. What are the different types of meetings? One is general meeting, one is board meeting. And next one is called as class meeting. Class meeting is nothing but any meeting conducted for a specific security holder. Imagine it can be for preference alone. It can be for equity alone. It can be for debentures alone. We call it as what, people? Class meetings. Whatever is the procedures, whatever the rules applicable for your, the general meeting, same thing will apply even for the class meeting as well. And different types of meeting in our syllabus for general meeting, we have two. One is called AGM, one is called EGM. Section 96 says a company has to conduct its AGM. The first AGM has to be conducted within 9 months of its closure of its financial year. Any subsequent AGMs has to be conducted within 6 months of the closure of financial year. So first AGM within 9 months, subsequent AGMs has to be conducted within 6 months of the closure financial year. And remember, the gap between two AGMs should not exceed 15 months. The gap between two AGMs should not exceed 15 months. So if you conduct one meeting today, now imagine in the month of April if you have conducted, then the next AGM, people, you should conduct it within you have to conduct it within 15 months. You have to calculate your 15 months here. Imagine if April 30th was my last meeting, then what will happen? April to May will be my 12 months. Okay. April to March will be my 12 months. April 30th, let us imagine we conducted our meeting. Then what happens? I'll start counting my month from April, May, from 1st May to April, it will be 12 months. May to April is 12 months, and April, May, June, July. Now, July will be my 15th month. I have to conduct my meeting, the next meeting within July. That is how you need to calculate your 15 months. Extension, if at any given point of time, if I am not able to conduct an AGM, this is not applicable for the first AGM, but for the subsequent AGM, I can always ask for extension. A one-time extension of 3 months will be granted. Where should I conduct my AGM? Remember, 3 questions can come here. 1, if you are a listed company, you need to conduct your AGM in the registered office or within the same city or town or village where your registered office is. If at all you are a unlisted company, you can conduct your AGM anywhere in India, provided it has to be first approved by all the shareholders. The answer is all. If you are a government company, you can conduct your AGM anywhere in India, provided the CG will decide where it is conducted. Remember this, very important exam point of view. You can conduct AGM any day except the national holiday, and you will conduct the AGM between 9 to 6. Once the AGM is done, you will file the report on AGM, what was discussed, what is the resolution passed, how many people voted, everything. You will file it with ROC in the form, according to section 121, to be filed by ROC with the ROC in 30 days of conclusion of the AGM. Remember that. Remember, section 96 is the AGM. The first meeting should be conducted within 9 months. The subsequent meeting should be conducted within 6 months. The time to conduct the AGM should be between 9 to 6. The AGM, the gap between two AGMs should not exceed, should not exceed 15 months. And if at all we are not able to conduct the meeting within 9 months, I can ask for extension of 3 months. Using 9(6), you can literally write the entire section. Remember, mere coincidence. That is section 96. Once 96 is done, the next section is section 100. What is section 100? EGM. EGM can be conducted by the company whenever the directors think so. Whenever they want, they can conduct. Remember, EGM of a company, which is can be held in any place in India. However, if it's a wholly owned subsidiary, it can be conducted even outside India as well. AGM cannot be conducted outside India. If you are a wholly owned subsidiary of a foreign company, you can conduct your EGM outside India, not AGM. Next one, EGM conducted by directors based on the request made by shareholders. How many people have to make a request? If a company has a share capital, then people holding at least 1/10 of the paid up share capital. If it is not having share capital, then 1/10 of the total voting power. So many people have to make a request to conduct a EGM. Hello? Board shall proceed to call the meeting within 21 days of the request. So I made a request today. The board has to start making the notices or anything within 21 days. And remember, people, whichever is the EGM conducted by the, okay, I'll tell that to you. Convene a meeting in 45 days from the request. And whoever are the people who made the request, everyone has to sign this EGM. Or if everyone is practically not possible to sign, they can authorize one person to sign the EGM notice on everyone's behalf. This is something which is very irritating me. I don't know when. I missed it. Okay. So you need to take steps in calling for the EGM within 21 days, like calling for a meeting and all, sir, and you have to conduct the meeting within 45 days. What if they did not do any of it? Then people, within 3 months from the date of making the request, the shareholders themselves can conduct the EGM. And remember, for the EGM conducted by the shareholders, you need not have to give any explanatory statement. It is okay, it is exempted. And even if one person signs, it is sufficient. Not entire requisionists need not sign. If they authorize one person, that person can sign. That is sufficient. Remember that. And whatever is the EGM conducted by the requisitionist, whoever made the request, the company shall give them all the details of shareholders, because register of members, everything should be given. Expenses shall be reimbursed by the company, which shall be deducted from the director's remuneration. To conduct a meeting, of course, they have to spend some money. That you spend first from your pocket as shareholders. Later, we will take it from the director's salary and we will give it to you. Next one, if quorum is not present within half an hour, because it is a requisitionist meeting, people, it will be cancelled. What about other meeting? If a quorum is not present within half an hour, people, the meeting shall be adjourned to the next week, same time, same date automatically, or such other date as decided by the board. Remember, for the adjourned meeting, again we will give a notice of at least 3 days. We will give at least 3 days notice for the adjourned meeting as well. But if the adjourned meeting is conducted anytime after 30 days, then you have to treat the adjourned meeting like a new meeting only. You have to give fresh notice of 21 days and you have to follow everything. Remember, it should be held at registered office or within city, town or village. Which one? The requisitionist meeting. And remember, if at all requisitionist meeting, if at all we did not give any notice to any person, and if it was accidental, voluntarily we didn't do it, was accidental, it will not invalidate the meeting, it will still be valid. Accidental omission is, it will still keep the meeting as valid only, it will not make the meeting invalid. That is section 96, section 100. What is section 97? If at all the AGM is not conducted, then upon an application, tribunal may tell the company to conduct an AGM. That is section 97. Tribunal conducted AGM. 98. Tribunal conducted EGM. 99. If at all the company does not comply with 96 to 98, then they will be paying a penalty. Remember that. 100. Done na? 101. What is 101, people? 101 is nothing but notice of a general meeting. Agreed? Hello? Okay, notice of a general meeting. And AGM the top 100 listed companies based on market capitalization, they need to conduct their AGM within 5 months of the closure of financial year. Remember that. Should OPC conduct AGM, Ada? Answer is no. Penalty for not conducting AGM. If any default is made in complying or holding a meeting of the company and every officer of the company who is in default shall be liable with fine, which may extend to 1 lakh rupees, and in case of continuing default with a further fine, which may extend to 5,000 rupees each day, during which such default continues. Okay. Next one, people. Notice of a general meeting, a company shall give how many days notice? It shall give at least 21 days clear notice. If it is a section 8 company, people, it will be read as 14 days clear notice. Can I conduct the meeting in a shorter notice? Possible. It depends upon which type of meeting. If it is a AGM, then the consent has to be given by 95% of the members who are entitled to vote. That means what can I say? Equity. So I have to, in case of AGM, by not less than 95% of the members entitled to vote. In case of any other general meeting holding, if the company has a share capital, then majority in number entitled to vote and who represent not less than 95% of paid up share capital are in value. What do I mean by that, people? If I want to conduct an EGM by shorter notice, then they're telling I need to satisfy people. This is majority number of members. Out of 10 people, I should take an approval from 9.5. Not possible. Imagine I have 100 people. I need to take an approval from 95 people. In the case of EGM, what does the law say? You need to get an approval from majority number. That means, let us imagine if I have 100 people I need to get an approval from 51 people, and this 51 people should hold 95% of the paid up share capital. I need to satisfy both conditions in the case of EGM. Remember, important. If the company has no share capital, then 95% of total voting power. That is important. Next one. The notice shall have agenda proxy. You have a right to appoint proxy. Is it optional? Mandatory. Every member has a right to appoint proxy. Persons entitled to receive notice, we will give it to every member. That is equity, preference, and their legal representative in the case of death. Assignee in the case of insolvent. We will give it to auditors also. Every director of the company. And in the case a private company which is not a subsidiary of public company may prescribe by its articles to whom the notice should be given. I can even tell it in my notice, in my agenda, in my articles of association, who are eligible to get the notice of the meeting. I can still say that. Where the securities are held singly, I can give it to the nominee of the single holder. Where securities, this is in the case of what? In the case of death. In the case of joint shareholders, we will give it to the surviving joint shareholder. If all the joint shareholder dies, then whoever is the nominee, we will give it to that person. Okay. Okay, next one is people section 102. What is 102? 102 is explanatory statement. It is mandatory only for a special business. Ordinary business is adda. Appointment of auditor, declaration of dividend, and what is that? Appointment of director in the case of retiring director. And next one is adoption of financial statements. So these four cases are adda, ordinary business. This has to be mandatorily conducted in AGM. Anything other than these four can be conducted in AGM or EGM. And remember, whenever you are discussing any matter other than ordinary business, you need to mandatorily give something called as explanatory statement. This is mandatory. So, sir, what do we give in that? You will give what to disclose. Any direct holding or indirect holding. Imagine, if at all a company X is entering into a contract with company Y, and my directors are interested in this. That means, let us imagine, if at all this contract goes through, it will give me some money. I'm earning some money because of that. Then I need to disclose nature of concern or interest of my director, KMP, and relatives of my KMP and director. What is the interest I have? I need to disclose. Next one, if there is any indirect interest. What do I mean by indirect interest? If business relates to any other company where promoter, director, manager, KMP have shareholding not less than 2% of paid up share capital, shall disclose the extent of shareholding interest. That means what? My directors this time are not having any interest directly, but they have shareholding in that other company. How much? If they have at least 2% of, meaning if they have shareholding not less than 2%, they need to clearly disclose. If this contract goes through, the company by I have a shareholding of, say, for example, 4%. It will give me an indirect benefit. We need to disclose this in the notice. If we don't disclose this, people, then remember, any gains made by the director, he needs to hold it on behalf of the company and he has to give it back to the company. Hello. Then next one, people, is section 102, 103. Okay. What is 103, sir? 103 stands for, people, your quorum of a meeting. What is quorum? Depends upon what type of company. If you're a public company, then the quorum is whatever is given in your articles of association, or if the number of members in your company is up to 1,000, then 5 members has to be personally present. More than 1,000, up to 5,000, 15 members personally present. Above 5,000, 30 members personally present. Now this will be my quorum. So whatever is given in my AOA or this, whichever is higher. Hello? Private company, nothing but 2 members personally present or whatever is decided by AOA, whichever is higher. What if no quorum is there? I told you, the meeting will be adjourned if the quorum is not present within half an hour. But if it is a requisitioned meeting, the meeting will be cancelled. Are preference shareholders counted for the quorum? Answer is no. If they don't have any direct interest, no. Proxy counted for quorum? No. Equity shareholder? Yes. Authorized representative? Yes. Nominee of president or governor? Yes. Authorized representative of nominee or authorized representative of governor or president of India, their authorized representative, yes, counted. And authorized representative of any company, body corporate, yes, they are all counted for the purpose of quorum. Okay. Chairman of the meeting, generally, who will allot? The member, generally, articles of association will allot the chairman. If articles are silent people, then the members personally present there will elect one amongst themselves to be the chairman of the meeting. The chairman is not present within 15 minutes people, then what will happen? Or if no director has been so designated, the directors present shall elect one of themselves to be the chairman. What if even the directors are not present within 15 minutes, sir? Then the members present there will elect one amongst themselves to be the chairman of the meeting. So first chairman, you should check if he is not there, directors will be the next chairman. If he is also not there, then the members present there will elect one amongst them to be the chairperson. The chairperson shall explain the objective and implication of the resolution. And remember, the chairman will have something called as people casting vote. What do I mean by that? Whenever there are 10 votes, imagine 5 say yes, 5 say no. Now, whenever there is equality of votes, whatever the chairman votes, whatever he says, that will be valid. That is only called as second vote, or that is only called as casting vote. Okay. What is this? A chairman cannot participate in any resolution in which he is interested. For that resolution, he needs to walk out, and after that resolution is decided, you can come back. That is what they are telling you. Adjourn meeting we saw 3 days notice. If it is more than 30 days, you need to give 21 days notice. Okay. An adjourn meeting, you can only discuss people whatever is the unfinished business. You cannot take up any new business in the adjourned meeting. Very important, remember that. Resolution passed at adjourned meeting. Now remember, the first meeting was conducted on, let us imagine, 5th August 2026. The adjourned meeting happened on 21st August 2026. We passed the resolution here. So what will be the date of resolution? Is it the first date or is it the actual date? It is always the actual date where the resolution was passed. From there only you need to count the 30 days or as the case may be. Okay, next one. Proxies. A proxy cannot speak in the meeting. Proxy is not counted for the purpose of quorum. And a proxy cannot vote on show of hands. Then what can proxy do? Proxy can demand poll. Proxy can vote also on poll. If at all a person is sending someone else as proxy, he needs to intimate the company at least 48 hours prior to the date of the meeting. Sir, what if the company says, I am entrenching my articles, it is not 48 hours, I want to make it as 72 hours. Remember, it will not be valid. It should be 48 hours only. Next one, sir. Proxy, a person can represent maximum how many people as proxy? The maximum he can represent is 50. And this is number of people. What is the value he can represent? He cannot represent more than 10% of the total share capital. That's the maximum he can represent. Sir, what if I want to represent 15 percentage? Can I do it? Yes, possible. Provided in such case you cannot represent more than one person. Remember that. Okay, next one. Proxy form will be in the form MGT 11. Inspection of proxy. Can I go and check the proxy forms? Imagine, as a shareholder, I am curious who and all are coming and directly attending the meeting, and who and all are attending the meeting through their proxies. I want to know. Can I know it? Yes. How? Every member entitled to vote, that means equity, at a meeting, to be more, is entitled to inspect the proxies lodged with the company if at least 3 days notice and writing is given to the company. Meaning I need to intimate to the company at least 3 days prior. I need to come and check the proxy form. I will intimate. Such inspection can be taken during the period beginning 24 hours before the time fixed for commencement of the meeting during the business hours of the company. What do you mean by that? Imagine if the meeting is happening on 12th of August 2026. They're telling you, when will the meeting start? Let us imagine the meeting will start at 9 a.m. on 12th of August. Then the inspection will start on 11th of August 2026 at 9 a.m. and it will end with the date of the meeting. So 12th, let us imagine the meeting ends at 12. At 12, the inspection also will be closed. Remember, when multiple proxies are appointed, the proxy that is appointed later will prevail, not the one prior. Remember, can preference shareholders appoint proxy? Answer is no, in general. Yes, people. The next one is your voting. So in section 106, what does section 106 say? Restriction on voting rights, correct? Now, in restriction on voting rights, section 106, important. What does it say? The articles of a company may provide that a member shall not exercise any voting right. Now, what if articles does not provide? Now, remember people, if your articles is silent, then you cannot restrict the shareholder from casting his vote. That's the point number one. Next one. Now, my articles can provide that if at all a shareholder does not pay his call money, that is your first call, second call, if you don't pay the call money or any other sum, you have taken loan, you have not paid the loan back, any other sum which is not paid by the shareholder, then people, we can say by articles of association, you will not be able to exercise the vote. You will not have a right to vote. Now people, in no other case, if my articles does not provide, or if at all in any other case other than calls or sums not paid, you cannot take away the right to vote from a shareholder. That is what, no member can be prohibited from exercising his voting right on any other ground. Very important, remember. Next one, presence of statutory auditor or secretarial auditor. Remember this people, in the AGM, a notice of AGM should also be given to the auditors. If the auditors are unable to attend the meeting, they need to send someone else to attend the meeting, and whoever attends the meeting shall also be qualified to be present and who should be able to solve the questions, and hence they should also be people auditors only, not a random person cannot come. So if a CA wants to come, if a CA is not able to come, he should send someone who is a CA only. If CS is not able to come, he should send someone who is a CS only. Clear? Okay, next one. Voting by show of hands. Always remember, by default, every resolution will be conducted by voting by show of hands only, unless and until a poll is demanded or the postal ballot is done or e-voting is done. Whenever a e-voting is carried on, then you need to do it by the poll. If e-voting is not done, people, remember, by default every meeting will be conducted by voting by show of hands only. Next one, sir, is okay, let us do demand for e-voting. What is e-voting? When is it mandatory? Applicability. E-voting comes into picture for all the listed companies and companies having 1,000 or more members. So listed companies also it is mandatory. Companies having 1,000 or more members also it is mandatory. Non-applicability. So even if I have more than 1,000 members, when it is not required. If you're a Nidhi company or if you're any institutional investors, for you this particular provision will not apply. The notice of e-voting can be sent by any of these methods. The contents of the notice. When I send you a notice of a general meeting, in that I should clearly tell you an option for you to available, the option available for you to choose e-voting. Remember, very required and mandatory. What is that? People, there was one question saying that whether e-voting is optional or mandatory. Remember, it is the company's mandate for you to provide e-voting facility. Whether you will choose or not is a secondary thing. The company should give you the option to vote electronically if the e-voting is applicable to you. It's not choice, it is mandatory. You need to clearly say login ID, password, time period. What will be the time period? The e-voting should be open for a minimum period of 3 days. It shall close the day before the meeting at 5 p.m. If the day of the meeting is say 24th of August 2027, the e-voting will conclude on 23 August 2027 at 5 p.m. Remember. And sir, what if I have already done my e-voting? Can I still come and attend the meeting? Answer is yes, but you cannot vote twice. Appointment of scrutinizer. Who can be a scrutinizer? It can be a CA, CS, CMA or an advocate in practice, or it can be anyone else who is not basically in the employment of the company. So technically you can appoint anyone as a scrutinizer. He will get the access to all the details of the company. The scrutinizer's report will be prepared not later than 3 days of the conclusion of the meeting. Result shall be published on the website of the company, and whosoever gave you this e-voting facility, and even on the stock exchange if at all you are a listed company. Remember, proposed resolutions, once it is done through e-voting, you cannot withdraw those resolutions. That is 108. What is 109? Demand for poll. Poll means what, people? Generally people, one person is equal to one vote. That is the meaning of show of hands. But whenever the voting is done by e-voting, poll, postal ballot, in such case people, remember, it is not one person is equal to one vote. It will be one share is equal to one vote. In this method, me and Mukesh Ambani are same. In this method, Mukesh Ambani and me, there is a huge difference. Any day Mukesh Ambani will win because of the voting he has, because of the shares he has. Remember it. Okay. Now, who can demand for a poll? First one, chairman can order for a poll at his own discretion. Next one, by chairman on a demand made by a company. If the company is having a share capital and people request for a poll, then it can be member or even proxy. Proxy can demand a poll holding 1/10 of the total voting power or rupees 5 lakh or more paid up. Remember, there is nothing called whichever is less, whichever is higher. So if you are holding 1/10 of the total voting power or the paid up value is 5 lakh, you can always demand for a poll. Next one, in the case of any other company, then 1/10 of the total voting power. Such people may request. Now, when can I demand for a poll? Remember, you can demand for a poll even before the declaration of results or even after the declaration of results by show of hands. You can demand the poll whenever you want. And remember, people, I made a request for a poll. Can I take it back? Yes, you can take it back. Poll can be withdrawn by the people whoever made it. And remember, you can withdraw it whenever you want. It can be even before the results, even after the results also you can withdraw. Not after the resolutions and all are drafted, not after the minutes are made. Sir, when should I take the poll? You have to take the poll immediately when the poll is for adjourning the meeting and for deciding the chairman. Then in these two cases, you have to take the poll immediately.
In any other case, people, you will take the poll within 48 hours. The polling paper will be in the format MGT12. The scrutinizer again will be appointed. He shall submit the scrutinizer's report in the format MGT13. It shall be submitted to the chairman within 7 days of taking the poll. That is your poll. The next one is called people postal ballot. What is the difference between postal ballot and e-voting? Don't get confused. Postal ballot is nothing but people for a wider participation of shareholders. That means we want everyone to participate. So what do? We say, let us not conduct a physical meeting. There is no physical meeting conducted. Instead of physical meeting, what do? We just conduct a meeting. It can be in electronic form, it can be in the form of postal card, however you want to do it. But there will be no physical meeting conducted. If you want, you can conduct, but it is not mandatory. So everyone will have a right to vote. In the meeting, what happens? Whoever attends the meeting, they will decide what to do. In a postal ballot, what happens? There will be no physical meeting. So everyone will get a right to participate in the resolution. That is called as what people? Postal ballot. Now, sir, for whom is postal ballot mandatory? Postal ballot is mandatory for any company if they are discussing any business other than ordinary business. Atta people cannot be done on postal ballot. You have to mandatorily conduct a meeting for this. Next one, any business where directors or auditors have a right to be heard. Can I say that removal of directors and auditors, you have a right to be heard? Now those things you cannot conduct it by a postal ballot. Remember, in our next chapter, directors chapter, this will come. Removal of director, I cannot do postal ballot. Technically people, section 115, special notice. Next one, postal ballot is exempted for who? For OPC, postal ballot is exempted. Any company having up to 200 members, the postal ballot is exempted. Remember, if you are having up to 200 members, I am not telling it is private company, even public company also can have up to 200 members, no. So up to 200 members, postal ballot is not mandatory for any company, whether you are a public, private or any company. Next one, following items should be mandatorily discussed through postal ballot. Go through this list. It has given various things. It can be alteration of object clause, small shareholder director appointment, variation of object clause, alteration of private company, conversion of private into public, public into private, buyback, all these are the examples. Go through that. Issue of DVR, as the case may be. Scrutinizers. You will again appoint scrutinizer not later than 7 days. Results will be declared on website along with the scrutinizer's report. Okay, done. Circulation of members resolution, section 111. What is circulation of members resolution? A company is conducting AGM. They want to discuss 8 matters. The shareholders want another 1 matter to be also discussed along with these 8 matters. Now, what do we say? We ask the company, sir, can you please also take up this 1 matter? They will give this resolution. What will the company do? The company will take up this matter. It will also further send it to all the other shareholders. Now, request will be made by a certain set of people. That is 1/10 of the people will make a request. The 9/10 of the people are not aware of it. So, the company will send this resolution to the 9/10 of the people. Agreed? Okay. Members can propose resolution for consideration which may be circulated to the other members if the company deems fit. Who can propose? Same as EGM, 1/10. Special conditions, such requisition shall be signed by all requisitionists. Sufficient money should be deposited for meeting circulation expenses. They have to deposit, circulation expenses, whatever is required, you have to deposit. Now, what time I have to deposit this resolution, sir? I have to deposit people. Requisition requiring notice of resolution, I have to give it at least 6 weeks before the date of the meeting. Now, when is the AGM? AGM is conducted on, let us imagine, on 30th September 2027. That is the date of the AGM. Now, what will happen? you need to give at least 6 weeks before. I'm just taking an example as say 13th August 2027. I need to give at least by 13th August 27 at least. Yeah, to be given minimum 6 weeks before. When the requisition require notice of resolution, meaning whatever is a request you are making, that request is such a way that requires a notice of resolution. In such case, I need to give 6 weeks prior. I need to give a request. So what if it is some other thing where I need not have to give a notice of resolution? In such case, I can give it even people 2 weeks before the date of the meeting. That means the date of the meeting is 30th September. Take 2 weeks. I'm just taking an average. Let us imagine 14th of September 27. So I have to give at least before 14th of September 27 if the request I am making does not require a notice of resolution. Hello? Okay. After depositing, what if the AGM is called before? They are telling you, I gave it 6 weeks before. What if they did not conduct the AGM on 30th September? They instead conducted on 10th September. But I gave it on 14th. After you gave an intimation, if they call for a notice, it is still considered as a valid resolution only. That is your section 111. Done. Next one, people. Section 115. We have already done 1112, 1113, 1114. What is this? This is nothing but authorized representative of body corporate and governor and president of India. 114 is nothing but people, your ordinary resolution and special resolution. Done. 115 is nothing but resolutions requiring special notice. Whenever people you do not want the same director to continue or same auditor to continue, you want to replace them, then you can make a special request to the company, please remove the auditor or please remove the director. How many people should make a request? It should be at least requested by the people who are holding at least 1% of the total voting power, or people holding at least 5 lakh rupees paid up. Again, same thing here. It does not say whichever is earlier, nothing. So if you are holding 1% of the total voting power, or people, if you are holding at least 5 lakh paid up, you guys can make a request. You need to send a notice to the company. You should at least send 3 months before the meeting. Yeah, to be sent at least 14 days before the meeting. What is that, people? Now imagine the date of the meeting is 30th September 2027. I should send it not more than 3 months before the meeting. That is, take September, August, July. 3 months means, people, I should not send it before 1st July 2027. I should not send it before that. And I should at least send before 14 days before the meeting. I'm just taking 14 days as, take 14 days, count it. Let us imagine it comes to somewhere around, say 16. I'm just taking. I will at least give it by 14 September 27. I should not give it after that. So you should give your request, people, within this time. Then now what will the company do? The company will take the request. They will further forward it to the other shareholders. If possible, you will give individual notice. If individual is not possible, people, then you will publish it on newspaper, and you will also publish it on the website of the company. 7 days notice you will give, English and vernacular. That is your 115. Done. Next one is, what is the other thing? 116 is your adjournment of meeting is done. Okay, this is important. 117. 116 is nothing but your adjournment of a meeting. We have done. Section 117 provides that certain things should be mandatorily informed to the registrar. What is that, people? Whenever in a company these things are decided, you need to mandatorily inform to the registrar. How? In the form MGT 14. When? Within 30 days. Sir, when should we do that? Whenever a company passes a special resolution, you need to intimate the registrar mandatorily, because we assume that something really important was discussed. So whenever a company passes a special resolution, you need to mandatorily inform to the ROC within 30 days in the form MGT 14. So when else we need to inform ROC? They're telling you the resolution which the law says you need to pass as a special resolution. Imagine if I'm altering my articles of association, I need to pass special resolution. The law said me to pass special resolution, but in my meeting, everyone agreed. So it became a unanimous approval. Still, law asked you to pass it as special. No, everyone might have agreed, but still, it should be passed as special. So even if everyone has agreed, you will still file it with ROC. Next one, any resolution of the board of a company relating to the appointment, reappointment, renewal of the main person managing director. So whenever you are appointing, reappointing or renewal of the appointment people of MD, when such person is appointed, you will mandatorily inform ROC. That's why you see MGT 14 being filed when you are doing the KMP chapter. Remember, MGT 14 will come. The reason is this. Resolutions agreed by any class of members, but which if not so agreed to, remember people, nothing but variation of shareholder rights. So there this will come, no, same thing will come, right? Whenever, if it is agreed by a certain set of preference shareholders, again you will file in the form MGT 14. Resolutions requiring for a company to be wound up. So when you decide to wind up, intimate ROC. Resolution passed according to section 179. What is 179? Powers of the board. Any other resolution or agreement as may be prescribed. So when all of these people are discussed, you will file it in the form MGT 14 with ROC. Next one, people, minutes of the meeting, section 118. Remember, you need to prepare minutes of the meeting for every meeting. You have to maintain a separate register. It can be for board, it can be for general. You have to maintain different minutes. Whenever you are maintaining minutes, remember you have to also follow SS1 and SS2 for all your meetings of board and general meeting. You have to follow SS1 and SS2 mandatorily. Next one, the minutes of the meeting can be maintained in electronic form provided. You need to have a timestamp, mandatory. The minutes of the meeting shall be consecutively numbered. All the pages has to be consecutively numbered and no page can be left blank. You have to score it off. And remember, the minutes of the meeting cannot be pasted, copied, tampered, altered. Nothing can be done. And the minutes can be maintained in three forms. One is electronic form. One is in a book form. One is in a loose leaf form, meaning in a single paper. Whenever you are maintaining in a single paper, you have to periodically bind them. The periodically is at least once in 3 years. You have to bind them. Place of keeping minutes will always be at the registered office of the company. The general contents of the meeting will be people who and all were present, where was the meeting conducted, what time it started, what time it ended. All that will be the general content. What will be the specific content? The quorum, the number of people present, who were present, all of that will be specific matters. Minutes of e-voting and postal ballot, it is nothing but you have to summarize even the minutes of the e-voting as well as postal ballot. It should still form part of your minutes of the meeting, mandatory. Recording of the minutes, very important. Can the chairman delete any content from the minutes? Yes, possible. Which one? If the chairman thinks if anything is defamatory to any person, or if anything is irrelevant, or if anything is immaterial, or if anything is detrimental to the interest of the company, these four things, the chairman has a right to eliminate it from the minutes, but you cannot eliminate any other information. And minutes are always prepared in the language of third person. That is, it is always prepared in the past tense. Entry in the minutes book, remember, within 15 days, the draft of the minutes will be prepared. It will be sent to all the directors present in the meeting once they confirm. It will be signed within 30 days. Who will sign? The chairman of the meeting shall sign. What if the chairman of the meeting is not available? If it's the board minutes, then the chairman of the current meeting or the chairman of the next meeting shall sign the minutes. Whereas if it is a general meeting, people, the chairman of the current meeting, whereas the chairman of the current meeting, if it is not available, then people, the board of directors shall authorize one person amongst themselves to sign the minutes. The minutes of the meeting, every page shall be initialed and the last page shall be signed. The minutes shall be preserved permanently throughout the life of the company. Remember, signing we saw. Manner of signing every page, 30 days, 15 days. Preserved permanently. At the meeting, register. Same thing at the meeting, during the meeting, virtual. Okay, what is virtual meetings done? Same thing, they will keep on saying the same thing. What do you mean by virtual meetings? Virtual meetings is nothing but people doing everything over electronic platform. Advantages and all is given. I hope this is manageable. There is nothing for us to discuss as such. Correct? Huh? So remember that. The only thing that we might have to discuss is the video conferencing. Whenever you are conducting meeting through electronic form, remember the roll call by chairperson, meaning the attendance will be called. The presence of quorum has to be done. The person present through electronic means will also be counted for the quorum. The director will have to introduce themselves first, and they should also tell people what. I am present from so and so, my name is so and so, I am present from so and so location. I have received all the agenda notices on time, and I have to clearly tell in the meeting room wherever I am present, there is no one else present in the meeting. The only exception is if at all I am a differently abled person, I have an option to get one more person with me, and he should also declare that he will keep all the information confidential. And we have to always sign the board minutes. Remember, the person attending the meeting through electronic means for him, a CS shall sign on his behalf. If there is no CS, then chairperson will sign. What if chairperson is also not there? Then any person who is authorized by the board, by any other director in the meeting, they will sign the attendance on behalf of the person attending the meeting electronically. 15 days, 30 days, done. That is people your minutes of the meeting. Yes. So okay, 1 second. You guys can go for a break and come, and you guys can resume your next chapter. Hello people. Let's start our next chapter. That is chapter 14. Now, what does chapter 14 speak about? It speaks about the directors. Now, the first part let us do with regards to the DIN. Now, what do the laws say? Every individual intending to appoint as a director shall mandatorily have a DIN. Now, how to obtain a DIN, people? It depends upon if it's a new company or if it's already a. Just a second. Hello. ನಿನಗೆ ಟೈಮ್ ಇದ್ರೆ ಒಂದು ಯಾವ್ದಾನ ಒಂದು ಎರಡು ಹುಡುಕ್ತೀಯಾ? Every individual intending to be appointed as a director shall mandatorily have DIN. How to obtain? Now, if it's a new company, people, then I need to apply it through my SPICE form. As simple as that. So, through my SPICE form, I'll be able to get it up to maximum of 3 people. Beyond that, sir, I need to go through people DIR 3. So applying through DIR 3, you will be able to get DIN. Now, who can apply DIN? It can be an Indian or it can be foreigner. Remember, for Indian, PAN is mandatory. For foreigner, PAN is not required. Then for foreigner, passport becomes mandatory. And not only that, the documents of the foreigner, it should be mandatorily certified by, basically you need to get it notarized and apostilled. What do I mean by apostille? Apostille is nothing but you need to get it certified by the Indian embassy there or your foreign diplomat office there. Now they need to certify the document. Yeah. For Indian, sir, it should be PAN, ID proof, residence, board resolution, and this is important. What is that? Your DIN has to be mandatorily signed by, DIR3 has to be mandatorily signed by whoever is the proposed director and anyone from the company where you are proposed as a director. From that company, someone has to sign. It can be CS in employment or a managing director, CEO, CFO of the existing company. Wherever I'm proposed as a director, now that person has to sign. Remember that. Next one, sir. Directors, KYC. Oh, sorry, where is that? Change in details, sir. My name changed, my address changed. I need to intimate all these changes, people, in the form called as DIR 6. I need to intimate to the ROC within 30 days of change. Remember, next one, cancellation of DIN. Can I cancel my DIN? Yes, possible. How? I can write to the central government or RD in the case of if I have two DINs by mistake, I can retain one, I can give up another. If at all I have obtained the DIN fraudulently, I can give up one. In the case of death, in the case of a person becoming unsound mind, in the case of a person becoming insolvent, I can cancel my DIN. Next one is called as surrender of your DIN. Can I surrender the DIN? Yes, possible, provided you can surrender the DIN only and only if you are not appointed as a director in any company and you should have not signed the document, any document you should have not signed using your DIN. If you have filed any document using your DIN, remember surrendering of DIN is not possible. So you should have not been appointed as a director in any company. Second thing is you should have not signed any document. How do I surrender the DIN? You will surrender the DIN in the form DIR 5. Sir, and once in a year, always remember every director should say to the central government that I am alive. How? You will have to file something called as DIR3 KYC web. It is nothing but confirming your phone number and email ID. A OTP will come to your phone number, a OTP will come to your email ID. You will say that none of my details are still changed and yes, I'm still in the same country. I'll give all my details. So, no, one second, what is this? So we will file this and we will give it to the ROC. So we will file this. So DR3 KYC web. Now, whenever there is any change in my number, whenever there is any change in my email ID, then I need to file a form called DIR3 KYC. Yes, so DIR3 KYC is filed if at all there is any change in my number or my email ID. And for the first time, you will file DIR3 KYC. Going forward, people, you will file DIR3 KYC web. Now imagine in the month of April, it has to be filed by September 30th every year. Now imagine my number changed during the year. I can get it done. I can file DR3 KYC in the month of May. Sir, I filed it. Again, my number changed. I want to intimate this in the month of December. Can I still do it? You can still do it. You will file DR3 KYC only. But people, you need to pay a fees of 5,000 rupees for the change. Meaning you need to pay an additional fees to make the change. You can still file. Okay. Failure to file, deactivation of a DIN. If you are failing to file this DR3 KYC, your DIN will be disqualified. Next one, sir, types of director. There are various directors. Let us take the important ones. Resident director. Who is a resident director, people? The person who has stayed in India at least for a period of 182 days during the financial year. We will call such person as a resident director. So one person should have stayed at least for a period of 182 days during the financial year. Remember, if it's a newly incorporated company, then it shall be taken proportionately. What do I mean by that? In general, for 365 days, I should have stayed in India for 182 days. What if I have incorporated my company in the month of 1st November 2026? My financial year will be 31st March 2027. Now, how many days are there? Let us imagine everything put together is coming to 150 days. I'm just taking an average. Now, I should have stayed in India for 365 days. I should have stayed for 182 days. Then for 150 days, how many days I should stay? I should do cross multiplication. That is the meaning of the note here. Done. Women director. Every listed company should have at least one women director, and every public company having a paid up capital of 100 crore or more and or turnover of 300 crore or more should mandatorily appoint one women director on the company. Remember recently, as per uh, your SEBI LODR, the top 1,000 listed companies shall mandatorily appoint one independent women director on their board. Every company, every top 1,000 listed companies should have one independent women director on their board. Remember that. Next one is small shareholder director. What do I mean by small shareholder director? Small shareholder director, every listed company may, upon notice, basically upon a request made by at least 1,000 small shareholders or 1/10 of the total number of such shareholders, whichever is less, appoint a person as small shareholder director. So minimum 1,000 small shareholders or 1/10 of such shareholders, whichever is less. So minimum 1,000 or minimum 1/10 of such shareholders, whichever is less. If a request is made by them, then people, I will appoint such person as a small shareholder director. So this appointment of small shareholder director mandatory on the company. Remember people, the words used are people, a listed company may. So it's not mandatory, it's optional. Now, sir, what do I mean by small shareholder? Small shareholder means a shareholder holding shares of nominal value of not more than 20,000. Remember, it's not market value, it's nominal value. Tenure, the maximum tenure of the small shareholder director people is 3 consecutive years. And he is not eligible for reappointment. Remember, he can be a small shareholder in not more than 2 companies, and that too, the second company should not be in a direct competition to us. He should not be associated with company in any other capacity for the 3 years from the date of cessation. Meaning, once you stop to be a small shareholder director, once you leave the company, you should not be associated with the company in any capacity for the 3 years. Additional point, he is counted in the total number of directors. I told you total he cannot be more than 2 directors. Such director may or may not be a shareholder, not liable to retire by rotation. Such notice seeking appointment shall be given at least 14 days before the meeting. Now this may or may not be, for this there is one point. Now what is that, sir? For small shareholder, we say, when will the small shareholder, when will his position come to an end? When he incurs any disqualification which is given under section 164. If he incurs any disqualification, he will have to step down as a small shareholder director. The office of director becomes vacant as per section 167. Technically, we'll be seeing both in our next chapters. He ceases to meet the criteria of independent. Remember, small shareholder director can also be treated as an independent director provided you satisfy the limits of independence. You satisfy the independence criteria. Next one, he ceases to be a small shareholder on and from the date of cessation. Meaning what? If at all my total value is going beyond 20,000, I become a shareholder of 30,000 value, I cannot continue as a small shareholder director. All these are the grounds for vacating my small shareholder directorship. Remember that. Okay, next one, appointment of other directors. First one is additional director. Remember, all these people are appointed by the board. That's why people, to appoint them, the power has to be given to the board by your articles of association. There should be the what do you say? The power given to them in the articles of association. So, what do you mean by additional director? Uh, Articles of association, if it is authorized, then the board of directors, the company itself may appoint any other person as a additional director. When will this happen? Imagine people, we need some our minimum number of directors have gone below the minimum requirement, or there is some seasonal capacity. We want one expertise for one particular season. Now, for all of this, I need not wait for a general meeting. The directors itself has a power. For a temporary basis, we can always appoint. The tenure of such a additional director will be up to the next AGM, one year. Whenever the AGM comes, people, your appointment will come to an end. But remember, the person who is being appointed as an additional director, he should not be a person who has been recommended in a general meeting, but the shareholders have rejected his recommendation. He should not be such a director. Clear? Alternate director, when will this happen? Whenever there is already a director. If the director is absent from the company for the last 3 months, he is not present because of any reason. In his capacity, another director can be appointed. We call such director as an alternate director. Remember, who will appoint the alternate director? The board will appoint, not the director who is absent. So the board has a right to appoint the alternate director. Okay. He should not already be a director in the company, and he should not already be an alternate director in the company also. So you should be a outsider. You should be a random person. Uh, He is appointed in the position of director absent and original director returns, alternate director appointment shall come to an end. When the original director comes, people, of course, the alternate director's appointment will come to an end. Next one, people, is nominee director. When will nominee director come, people? Whenever financial institutions or the banks, creditors, when they give loans, they would want to safeguard their interest by we would want to know what is happening on the board. So what will they tell? They will tell one amongst no many directors, one person should belong to us. If they come with such condition, people, we call such people as nominee directors. So articles of association should authorize the company which secures financial assistance from banks may appoint a nominee director, and remember, they can't be removed by the company, and neither they will be proportional representation. All these things will not apply to this nominee directors. Next one, people, is casual vacancy. What is casual vacancy? Whenever a director is resigning in between. Now what will happen? The directors can appoint someone else in that capacity. Now, for example, the shareholders have appointed one director. Now this person resigns in between the year. So the rest of the directors can appoint someone else in his position. We call such director appointed as casual vacancy. Remember, whenever you're appointing a casual vacancy, such a appointment should be ratified by the shareholders. It has to be approved by the shareholders in the next general meeting. Whichever is the next immediate general meeting that is happening, in that people, his appointment has to be ratified. Now, what will be the tenure of this person? His tenure will be as per the tenure of the original director. If another 3 years is pending, even he will be also appointed for another 3 years. This is, people, casual vacancy. Clear? Okay. Next one. Okay. Independent director. With regards to independent director, the only thing I want you guys to do is, what is an independent director? Instead of me just reading it out, I have already uploaded a full video on what is an independent director. I would recommend you guys to please watch it. The complete provision of independent director I have uploaded on YouTube, the CS channel of Arivupro. The entire independent director provisions are there. Please watch that one thing. The rest of it I'll do it here. Kira? Okay. So, sir, independent director, sir, when, how, what? Independent director, first one, people, as per Companies Act, as per SEBI LODR, how many independent directors has to be there? First one, people, as per Companies Act. Companies Act says every listed company should have at least 1/3 of its board as independent directors. Unlisted public companies who is having paid up capital of 10 crore or more or turnover of 100 crore or more and aggregate of outstanding deposits, debentures, loans exceeding 50 crore. Remember that. This is 10 crore or more, 100 crore or more. This is exceeding 50. That means 50.1 should be there. Such unlisted public companies should have at least two directors as independent director. This is as per Companies Act. What is as per SEBI LODR? As per SEBI LODR, it depends upon your chairman. If the chairman of the board is a non-executive director, then people remember the board of directors, one third shall be independent. If at all the chairman of the board is a executive director, then people, half of the board shall be independent. So if the chairman is non-executive, then people, one third shall be independent. If chairman is executive, if the chairperson is executive, then half of the board shall be independent. What if the chairperson is non-executive director but related to the promoter group? If that is the case, then also people, half of the board shall be independent. Remember that. Clear? This is as per SEBI LODR. Tenure of independent director people, he will be appointed for a period of 5 years. Can we reappoint the person? Yes. How? By passing a special resolution. Correct? Yes. Remember, can I again appoint him for one more term? No. Once the two terms are done, people, you need to have a cool off of people 3 years. Until 3 years, you cannot appoint the same person again as a independent director. Now, recently there is a change. What is that? Whenever we are appointing, sir, one more thing, people, whenever there is a casual vacancy, we need to fill the casual vacancy within the 3 months from the date of vacancy or not later than immediate next board meeting, whichever is later. 3 months time or board meeting, whichever is later, we need to fill the vacancy of the independent director as per this particular scenario. Next one, sir. This is important. What is that? Remember, today's date, whether you want to appoint as per SEBI LODR, reappoint or remove an independent director, then it should be subject to the approval of shareholders by a special resolution. So according to LODR, it is very simple. If I want to appoint, reappoint or remove an independent director, I have to mandatorily pass a special resolution. However, they have passed one amendment. What is that? Provided that where a special resolution for appointment of an independent director fails to get the requisite majority of the votes, that means we did not get 75%. So can we appoint such person as an independent director? Answer is technically no. But still we can appoint the same person as an independent director itself. When? How is that possible? To appoint the same person as an independent director, sir, for that the following condition has to be satisfied. What is that? The votes cast in the favor of the resolution exceeds the votes cast against. That means we wanted to appoint Mr. X as an independent director. We got 55% of the votes in favor and we got 45% of the votes against. Now what to do? Now there is a second condition. What? And the votes cast by the public shareholders in favor of the resolution exceeds the votes cast against the resolution. What do I mean by that? Sir, in this 45%, let us imagine 10% of the public said no. Then people in the votes cast for the people, that is favor of resolution, should be at least 11%. So public shareholder saying no, public shareholding saying yes, it should be more. So if both the conditions are satisfied, people, then I can appoint such person as an independent director even if I do not get a special resolution possible. Done. Next one, sir. Same thing applies, people, when I want to remove the independent director as well. So first try to pass special resolution. If special resolution is unsuccessful, then what do? You guys can pass majority and public majority will be considered. Done. Next one, sir. What else? Declaration of independence. Always remember, An independent director, whenever he is appointed, he needs to give a declaration that he is an independent director. He satisfies the section 149 subsection 6. Whenever he is appointed, next one, every first meeting of the year, I need to again give a declaration that I am an independent director. Next one, whenever there is a change, as soon as a change is done, meaning I lose my independence, I need to immediately give a declaration. So the declaration of independence has to be given in these three scenarios. Done, done. Remuneration of an independent director, remember, he is not entitled to any stock options, but you are entitled for remuneration. You are also entitled for sitting fees. You will not be paid anything more than 1 lakh rupees. You can be paid salary as a commission also on profits. It is allowed. Appointment of an independent director of unlisted material subsidiary company. What is it, sir? As per regulation 24 people, at least one independent director on the board of a listed company shall be a director on the board of an unlisted material subsidiary company, whether incorporated in India or not. Explanation: material subsidiary shall mean whose income or net worth exceeds 20% of the consolidated income or net worth of the listed company and its subsidiaries. What do I mean by that, sir? Let us imagine, people, there is a company called Tata Motors. Now, this has a subsidiary company called Jaguar. Along with that, it has another subsidiary company called X, another subsidiary company called Y. Now, if I take the total example I'm taking, let us imagine if I take the total income of Jaguar, X company, Y company, Tata Motors, everything put together, the total income is coming to 1000 crores. In this 1000 crores, Jaguar alone's income, people, is around 250 crores. That is, it is exceeding 20% of the total overall income of all our companies put together. In such case, what is happening, people? We call this company as a unlisted material subsidiary company, Jaguar. Whether you are in India or outside India. Now what happens? Tata Motors is a listed company. One independent director of Tata Motors should be a director, whole-time director in Jaguar. Remember, that is what is this condition. Exam point of view, important. Next one, sir. What is that? Okay. Data bank, people. Now today, remember, for you to become an independent director, people, you need to clear the exam. Only the people who are able to clear the online proficiency self-assessment test. If you're able to clear this, only then you can become an independent director. How is that? Whoever are the current independent directors, they are given 13 months time to clear the exam. Whoever wants to become an independent director going forward, then, people, once your name is entered in the in the data bank maintained by IICA, Indian Institute of Corporate Affairs, you need to clear the exam within 2 years of your name being entered in that IICA records. So once you need to register yourself under IICA, once your name is registered, within 2 years you need to clear your exam. If not, people, you will not be able to become an independent director. Is this clear, all of you? Done. Next one, sir. What is the maximum number of directorships, people? A person can become a director maximum of 20 companies. In that 20 people, 10 can be public companies, the rest of it can be other type of companies. And remember, if I'm a director of listed companies, I cannot be a director of more than 7 listed companies. And I can be an independent director also on 7 listed companies. But remember, if I am a whole-time director or a managing director in any listed company, then, people, the maximum number of companies on which I can be an independent director cannot exceed 3 listed companies. So if, for example, Mukesh Ambani is a managing director of Reliance, he cannot be more than independent director in more than any other 3 listed companies. Remember, when you are calculating the directorships in Section 8 company, dormant company shall not be included. Hello? Done. Independent director, done. Appointment of directors. How do we appoint the directors, people? First of all, the whoever is a proposed director, they need to give us a consent. That is only called as DIR2. And whenever a director is appointed, people, I need to file form DIR12. And director shall be appointed by shareholders in a general meeting. Exception is section 161. Alternative, additional, casual vacancy. Whenever a director resigns, also people, you need to file form DIR 12 only. So appointment of a director and removal, cessation of a director, also you need to file form DIR 12 only. Next one, retirement of director by rotation. What do I mean by retirement of director by rotation, people? In case of public company, generally what happens, if you are appointing any person as a director, they will not, vacate their office only. They will sit in that office forever. Can they sit in the office forever, people? Like every employee will have deliverables. If you don't deliver, you will be removed. In the same way, even a director also should be removed if at all he is not delivering whatever he has promised to do. Yes or no? So people, that is only called as people retirement by rotation. By default, if a public company does not say all my directors are liable to retire by rotation, if the public company does not say so, then out of your total directors, always remember 2/3 of your directors are always liable to retire by rotation. In this 2/3 people, 1/3 of the directors shall retire by rotation every year. That means if I have total 9 directors, out of 9, 6 directors every year, people shall be liable to retire by rotation. Out of 6 people, 1/3 shall retire. That is, people, 2 directors shall retire every year. If you really like them, if you think they are fit, you can reappoint them. But at least let them retire, no? They know that they can retire. If they are not performing good, then don't reappoint them. Yeah. And always remember, a single resolution to appoint 2 or more directors cannot be passed. Appointment of director should always happen through individual resolutions. Sir, what if I want to appoint 2 or more directors in a single resolution? Then first you need to pass a resolution asking for the shareholders' approval. People, I want to appoint all the directors in one resolution. Is it okay? If the shareholders first agree for that, then you need to first unanimously take that approval, and then you need to take the approval. And then you need to pass the resolution to appoint the 2 or more directors. So first you need to pass a resolution asking their approval to do or to appoint the directors in a single resolution. First you need to pass a resolution for that. Next one, sir. Right of person other than retiring director to stand for directorship. What is the section 160, sir? Remember, people, now can I nominate anyone as a director to stand for Infosys directors, election? Imagine I want this fellow to become a director. Can I do it? Is it possible? They're telling you yes, possible. Why not? Now that is what they're telling you. Right of person other than retiring director, you can stand for directorship. How? Any person or member intending to propose him as a director, whoever want, they can propose. 14 days before the general meeting, people, I need to give my notice. I am proposing Mr. A to be appointed as a director. I need to give his candidature along with his consent, that is DIR2. He should also hold it in. I need to give this notice 14 days before the meeting, along with the security deposit of people 1 lakh rupees to the company. So what will the company do? The company will take it, it will circulate to all the other members 7 days before the meeting. How? By notice, if individual notice is possible, and they will also publish it on the website of the company. And also remember, they can also publish it if individual notice is not possible. You can publish it on people, what is that? On the website of the company. That is on the in the newspaper. The newspaper can be English and vernacular. Remember, in the case of Nidhi company, this will be not 10 lakh, 10,000 rupees in the case of Nidhi company. Sir, this 1 lakh rupees, whatever I'm depositing, this 1 lakh rupees, will I get it back, sir? To get it back, people, either you need to win that directorship or you need to at least get 25% of your total valid votes. If yes, you will get back your money, whatever you have deposited. That's all. Done? Done. Next one, sir. Vacation of office of a director, 167 and 164. Both are important, remember. Sir, if at all a director, if any of these things happens, people, that is a disqualification. You need to leave the company. When, sir? First one, if you absent yourself from all the board meetings that is conducted in the last 12 months, that is one of the disqualification, you need to leave. A disqualification order is passed by any court or tribunal, leave. Incurs any disqualification specified under section 164. What is 164? We will see. You will have to leave. Hello? Okay. Next one. We will see in 164 there is one more catch. Convicted of any offense, imprisoned for a minimum period of 6 months. What if convicted for less than 6 months? Imprisoned for less than 6 months. Less than 6 months, people not disqualified. 6 months or more is disqualified. Remember that, important. You have been removed as per the act, disqualified. Ceases to hold office in that company. What is that? You saw just now. Independent director of a listed company shall be a director in the unlisted material subsidiary. Now, if I cease to become an independent director in a listed company, I will also cease to become a director in the unlisted material subsidiary company. Correct, Tom? So that is what they are telling you here. Next ones are disqualified under 164. In that 164 also, people, there are two types of defaults. One is 164.1, 164.2. What does 164.1 say? That is, director only gets disqualified. Example, unsound mind, insolvent, or you have filed your insolvent application, it is not yet approved, but you have filed. You have been convicted of an offense and you have been imprisoned for a minimum 6 months. And there is a cool off period, people, 5 years. If you are imprisoned for minimum 6 months, people, you cannot be appointed as a director for the next 5 years. And remember, people, if at all you are imprisoned for more than 7 years, then you are permanently debarred from being appointed as a director. Remember that. Next one, who else is disqualified? If at all you have not paid the call money, you are disqualified. Call money, first call, second call, you're paid up. Convicted with offences related with related party transactions, disqualified. Does not possess DIN, of course disqualified. Holding more directorships than allowed, 20, 10, 7, 3, disqualified. Disqualifying order passed by court or tribunal, which we already saw. You have to vacate. Now this is a personal incapacity that the director is happening. Next one, people, director did not do anything, but he is part of a company which has disqualified. Like disqualification if he or has been a director of a company which has committed default of what? Company has not filed the financial statements or annual returns for a period of 3 continuous financial years. Disqualified. Deposits or interest thereupon, debentures or interest upon, or if you have declared a dividend but you have not paid it. In such case, people, and if that failure continues for 1 year, again, people, you are disqualified. But remember, people, whenever you are disqualified, I need to vacate the office, yes or no? But there is one thing here that you need to remember. What is that? Whenever 164 subsection 2, if I am disqualified, in such case, people, I need to vacate from all the other offices where I am a director except the place where the disqualification happened. Example, I am a director of company X and Y. The disqualification happened in the company X. I can continue in the company X until my tenure. But in company Y, I will be disqualified, and hence my appointment will come to an end. I'll have to vacate the office. And once I vacate the office, remember, I cannot be appointed in any other new company as a director. There is a cool off period, 5 years. I cannot be appointed in any other company. Sir, can I be appointed again in the same company where disqualification happens? No, once your tenure is done, You will have to leave the company. You cannot be reappointed again in the same company as well. Remember. Clear? Okay, next one, resignation of a director, section 168. Can a director resign? Yes, people, same thing. You resign, you intimate the company will intimate the ROC within 30 days in the form DIR 12. Sir, what if the company does not intimate? Then, macha, you also can intimate, but it's an option. In a form called DIR 11, you can intimate within 30 days of resignation. You can only intimate to ROC. Sir, what will be the effective date of resignation? If you have mentioned any date in your notice, as this is the date I want to resign, that will be the date. If nothing is mentioned, people, then whenever the company receives the notice, that will be the effective date of resignation. Is this clear? Hello? Done. Next one, sir, loan to directors. Now, what is this loan to directors? Important. What is that? Can I give loan to the directors, or can I give loan to those people in which the director is interested? Is it possible? That is what they're telling you. See, company shall not give directly or indirectly loan, book debt, guarantee, comma, security. We cannot give any of these things, it seems. What is that? To whom? It is not allowed. I cannot give any loan, book debt. What do you mean by book debt? For example, we are the company who is into manufacturing and selling of TVs. We give our TV to the director on EMI, or we tell him it's okay, don't pay, or pay later. It becomes a book debt. You're not supposed to give any of it to the Sims. If you're treating him like any other customer, that's okay, but you cannot give any special preferences. So, director of a company or a director of a holding company, I cannot give any debt. Next one, I cannot give any debt to a partner or a relative of a director. So, let us imagine the case of Reliance. Who is my director? Mukesh Ambani. Mukesh Ambani ka relatives, children and all, wife, I cannot give. If Mukesh Ambani has a partnership firm, in that partnership firm there is a partner. To them also I cannot give. Sir, okay, you will not give it to a partner. Can I give it to the partnership firm? Of course, I cannot give it to the partnership firm also. So I can neither give it to the firm, neither can I give it to the partner. Next one. Some cases it is allowed it seems. You can give a debt when the company may provide to person in whom director of the company is interested, not the director. Wherever my director is interested, I can give a debt it seems. When the person in whom the director of the company is interested means it should be a private company in which the director is a director or a member. That means XYZ Limited wants to give a loan to XYZ, or let us imagine ABC Private Limited. Now, why is ABC Limited? Why ABC Private Limited? Why are we able to give? They're telling you, whoever is my director in XYZ Limited, he is a director in ABC Private Limited or a member in ABC Private Limited. Then people, I can give loan to this ABC Private Limited. Next condition, body corporate in which 25% of total voting power is held by a director or two or more directors. That means our XYZ Limited can give loan to a body corporate. Let's imagine LLP, where my director or my two or more directors, they are holding at least 25% of the total voting power in that body corporate. Next one, body corporate whose directors or managers are accustomed to act in accordance with the director of the lending company. What do I mean by that? There is XYZ. In this, we have a director. There is ABC. Say, for example, ABC Private Limited. In this, there is a director. His name is B. B listens to whatever our director says. I tell him to do, he does. I tell him not to do, he will not do. Now, people, whenever we are giving any loan to such person, they're telling you this is also okay. This is considered as a company where the director is interested. Sir, we can give it to all these three people, provided what is the procedure? Procedure is, people, you need to pass a special resolution, and whoever is the borrowing company it should utilize the money for its principal purpose, that is people, your object clause. You should utilize for that purpose only. You should not utilize that money for any other purpose. If that is the case, people, it is allowed. If not, people, it is not allowed. Next one, sir, non-applicability. This section 1 and 2 does not apply to who? This is very, very important. Any loan given to the managing director or whole-time director, no other person, as a part of condition of service extended to all its employees. What do I mean by that? Being an employee in a company, everyone will have an option to take salary loan. Like that only we are giving an option for the MD also, but there is no discrimination. Or, sir, no, there is no such condition. We can take special resolution, shareholders agreed, and only then we are giving the loan to managing director, it is allowed. Next one, company giving loan guarantee security in ordinary course of business given for due repayment of any loan, and interest charged on such loan is not less than prevailing yield of government securities closest to the tenure. What do I mean by that, sir? Now, banking company gave loan, people. That's the ordinary course of the business of the company. That's why they give. Then what else I can do? I can give a loan, people. It's absolutely fine. Yeah. However, the interest charged on such loan is not less than the prevailing yield of government securities. Meaning what? Now remember, government securities is giving at least the interest of 7%. So you should at least charge from the director at least 7%. Next one, any loan guarantee security made by holding company to wholly owned subsidiary. You can give a holding company can give it to wholly owned subsidiary. Guarantee or security provided by holding company in respect of the loan made by subsidiary company. You can only give loan, or if the subsidiary company is borrowing loan from someone, the guarantee can be given by the holding company. It is allowed, provided the money received by the subsidiary company, they have to use it for compulsorily their principal business activity for no other purpose. Last one, sir, this entire section shall not apply to a private company which is whose share capital nobody should have invested money. Basically, what do you mean by this, people? No body corporate should have invested money. See, my God, Shantam Papam. In whose share capital no body corporate should have invested money. That means, let us take, for example, there is XYZ Private Limited. Who is the shareholder of XYZ Private Limited? Sorry, everyone are individuals only. There is no company who is a shareholder. If a company is a shareholder in XYZ Private Limited, they cannot claim an exemption of 185. Second one, borrowing is less than twice of its paid up share capital or 50 crore, whichever is less. Sir, XYZ paid company has a paid up capital of 10 crore. What is the twice of it? Twice of it is 20 crore. What is the total loan in the XYZ Private Limited? Total loan is, sir, somewhere around 30 crore. Sir, if the borrowing is less than twice of its paid up share capital or 50 crore, whichever is lower. Now you tell me, people, 20 crore or 50 crore, what is lower? 20 crore is lower. And how much is your borrowing? Borrowing is 30 crore. Then, people, you are not qualified. You are not exempted from this particular condition. Next one, no default in repayment of any borrowings. Next one, Nidhi loan given to director in the capacity of a member. In a case of Nidhi company, that's their objective. It is allowed, it is absolutely fine. There is no restriction. Yes, sir. So the most important topics, whatever is there, I've tried to cover everything in this particular section. Yeah. So let's take up the next chapter. What is the next chapter? Let's go to chapter. Yes, people. So let's start with the next chapter. Chapter 15, board composition and power of board. Okay, directly let's go. Composition of the listed entity, which we already seen in the previous chapter. Again, I'm not going in detail there. The next thing is people section 180, which speaks about the restriction of power of board. What is restriction of power of board? Which speaks about what is the things which the board cannot do on their own. If it is coming under section 180, they can do it, people, only after passing a special resolution. Without passing a special resolution, they cannot do this. Now, what is that? First one, people, is to sell, lease, dispose, whole or substantially the whole of the company's undertaking. Now what is that? Now what do I mean by this undertaking, substantially the whole of undertaking? It is nothing but an undertaking can be defined as, it shall mean an undertaking in which the investment of the company exceeds 20% of its net worth, or an undertaking which generates 20% of the total income of the company during the previous financial year. Now, for example, let us imagine Arivupro, we have 5 branches. In 5 branches, if there is any one branch where our investment is, they're telling, exceeding 20% of our total our net worth is there, or exceeding 20% of our total income is coming from this one branch, then we call that as an undertaking. What do I mean by substantially the whole of the undertaking? In any financial year shall mean 20% or more of the undertaking as per the audited balance sheet. That is nothing but, people, substantially the whole means more than 20%. Technically, this is the meaning. I getting the point now? So, the expression substantially the whole of undertaking in any financial year shall mean 20% or more of the value of the undertaking as per the audited balance sheet. Now, what is undertaking? We got to know. 20% of the undertaking, if at all you are selling, you are leasing, you are disposing. So, one branch we are selling away, we are leasing it away. So, if there is any undertaking which is generating 20% of the income, and if that particular branch, if we are leasing it out or selling that branch out, then we can do it only after passing the special resolution. Next one. Where is that? Okay. To invest in securities, the amount of compensation received from a merger or amalgamation otherwise than in securities. What is this, sir? To invest otherwise in trust securities, the amount of compensation received by it as a result of any merger or amalgamation. That means what, people? To invest otherwise in trust securities means what, people? Trust securities is okay. If you are investing otherwise than in trust securities, you need to invest only after passing a special resolution. Now what is this? Let us imagine, people, Vodafone Idea came together. If they are entering into a merger, now the new company will give purchase consideration to the previous shareholders, right? Money will be settled, or shares will be settled, debentures will be settled, something will be settled. They are telling you, whenever a company, if it is getting purchase consideration, the money, before it settles it to the shareholders, if this money is being invested into any other place, if you are investing it in the trust securities, that is okay. But if you are investing it in any other place, people, you can do it only after passing a special resolution. Okay, done. Next one, to borrow money, old plus new, something which is already done, plus whatever is the new money you are going to borrow, new loans you are going to borrow. If it is exceeding your paid up capital, free reserves, plus securities premium, if it is exceeding the aggregate of this, then people, remember, you can only borrow that money after passing the special resolution. I get in the point, only after passing the special resolution you can do so. Okay, done. Now, it does not include temporary loans. What do I mean by that, sir? Whenever I am borrowing these loans, imagine in this old plus new, I need not have to take any short-term loans borrowed. What do you mean by short-term loans borrowed? Short-term loans means, people, any debt which has to be repaid on demand or within 6 months, we call it as short-term loans. You need not have to add short-term loans in this. So old plus new, if it is exceeding aggregate of your paid up share capital, free reserve, securities premium, such loans cannot be borrowed without passing a special resolution. Okay, next one, to remit or give time. This you will be seeing when we are doing section 197. I will tell you when we are doing KMP chapter. Next one, contribution by board. Can we contribute? Yes. Charitable funds. What is the maximum we can contribute? The maximum we can contribute, these people, the board of directors can contribute 5% of my 3 years average net profits I can contribute. If at all I want to contribute more, then I need to take prior approval in the general meeting. Next one, political contribution. Can I do political contribution? Is it allowed? They're telling you political contribution can be made. Any limit? This is the irony. Without any limit, it seems. No limit at all. Yes, but certain companies cannot make political contribution. Which one? Government company. Of course, whoever is a ruling party, they are going to contribute to them only. Then where is the purpose served? Second one, any company who is recently incorporated, you are in existence for less than 3 years. Now these two companies cannot make political contribution. Third point, whatever is a contribution you are making, remember it has to be made in a legitimate form. That means it can be used, it can be made by check or it can be by electronic clearing system. That is nothing but NEFT, IMPS as the case may be. So not in cash, that's the meaning. And remember, whatever is the payments you guys have made, you need to disclose that in your P&L account of whatever is the expenses you have given. National Defense Fund people, same thing, you have to disclose in the P&L account. And board is authorized to contribute such amount as it thinks fit. So there is no limit. So these are the contribution. 180 is restriction on power of board. 181 is charitable, 182 political, 183 is your defense fund. Okay, next important thing in this particular chapter, people, is committees. Directly go to committees. Now, what are the different committees, sir? The first committee that we have, people. Now, do not concentrate on LODR when you are doing Companies Act. When you guys are doing CMSL, do not do not concentrate on Companies Act when you are doing CMSL. Okay, now the first thing, sir, is audit committee. Audit committee, which is given under section 177. If LODR, that means it is regulation 18 of LODR. Applicability, same as independent director. What do I mean by that? Audit committee is applicable for every listed company, all public companies who is having a paid up capital of 10 crore or more, all public companies having turnover of 100 crore or more, all public companies having outstanding loans, debentures, deposits exceeding 50 crore. 50.1 should be there. Remember, important. The following classes of unlisted public companies shall not be covered for the above purpose. That means, if you are a joint venture, wholly owned subsidiary and a dormant company, even though your limits are coming as per this, these companies still need not have to form the audit committees. Okay. Next one, who will be the members of audit committee? The audit committee shall consist of minimum 3 directors. 3 directors. In that, people, independent directors will be forming the majority. Okay. Financial literacy, very important. Remember, the majority of the members of audit committee, including the chairperson, shall be financially literate. What do I mean by financially literate? The people who are able to read and understand the financial statements, we call them as financially literate. Remember, in the case of LODR, you will have financial expert. That will not come for Companies Act. I am not touching LODR now. Next one, sir. Chairperson of Companies Act. As per Companies Act, who will be the chairperson of the committee? Chairperson is not prescribed anything here. Yes, sir. Next one, role of audit committee. We will see. Basically, omnibus approval and all of that. Next one, evaluation of internal financial controls and risk management and all of that. Role only, no. Okay, power and all. We'll be seeing when we are doing the audit committee only. The omnibus. What is the frequency of the meeting? Articles does not provide. Your Companies Act does not provide. Quorum, people, remember, the Companies Act does not provide anything. But if Companies Act does not provide anything, then what do? You have to follow your Articles of Association. According to Articles of Association, if you have prescribed whatever is your quorum, that will be my quorum. Sir, what if my Articles of Association is silent? Remember, people, if your Articles of Association is silent, in such case, people, all the board of directors should be present to constitute a valid quorum. Now, where is that given? That is given under Secretarial Standards 1. Remember, very, very important from the exam point of view. That's all done. Next one is, people, vigil mechanism. What do I mean by vigil mechanism? Vigil mechanism can also be called as, people, whistleblower policy. In your company, you need to have a mandatory mechanism where if at all your employees, directors, officers, if they come across any discrepancies, non-compliances, violations, fraud, they should be able to address it. They should be able to go and inform about it in some place. Now, sir, every listed company and companies which have accepted only deposits from public, I'm talking about section 76, and the companies which have borrowed money from banks and public financial institutions in excess of 50 crore, you need to mandatorily have a vigil mechanism. Why? Vigil mechanisms will help. If an employee is coming and sharing his thoughts, or if he is sharing the non-compliances, remember, the vigil mechanism shall provide for adequate safeguard against victimization of employees and directors. You cannot harass them. And remember, people, if needed, we can also give you a direct access to the chairperson of the audit committee. And remember, secretary of audit committee will always be a CS. Okay. Omnibus approval will come back. Nomination and remuneration committee, people, what is that? Section 178, regulation 19. Same as your independent director. What is that? 10 crore, 100 crore, exceeding 50 crore. Joint venture company, wholly owned subsidiary company and dormant company need not form NRC. Constitution of committee of members, NRC people shall consist of 3 or more non-executive directors. Remember that. And 1/2 of the board shall be independent. People, in the case of audit committee, it was 3 directors, majority shall be independent. Here everyone should be non-executive, and they're telling you half of them should be independent. There it is majority. Remember the words. Chairman, silent. Role of NRC, nothing but nominate the directors, fix their remuneration, review their performance. All these things will come there. Frequency of meeting, silent. Quorum, people, same thing. Whatever we saw in audit committee, as per AOA, if AOA is silent, SS1 will prevail. Remember, important. Next one, people, stakeholder relationship committee. What do I mean by stakeholder relationship committee? Section 178 speaks about it, and regulation 20. Stakeholder relationship committee means nothing but, people, it is the responsibility of them to address if any discrepancies are there by any shareholders, debenture holders. If they face any issues, they should be able to reach out to someone, right? That someone is, people, stakeholder relationship committee, something like grievance redressal. So who should appoint? The company which consists of more than 1,000 shareholders, debenture holders, deposit holders, and any other security holders at any time during a financial year shall constitute a stakeholder relationship committee. I can take it as an aggregate limit. Everything put together 1,000 also, people, SRC will be applicable. Listed company, don't check anything. Mandatorily applicable. Members, nothing prescribed. Chairperson, chairperson shall be a non-executive director. And the role of stakeholder relationship committee is nothing but grievance redressal. Remember, frequency does not describe. I mean, our what is that? Companies Act is silent on it. Next one, people, risk management committee. Companies Act as it is does not apply. Technically, we can skip also, but on the face of it, you see, risk management committee, people, is covered under regulation 21. Risk management committee, who and all will have to comply with it. First of all, it is not applicable for unlisted company. For a listed company, top 1,000 listed companies, and recently they have added one more thing, people, high value listed debt. High value listed debt. Such companies also will have to mandatorily have a risk management committee. Now, what is the composition of risk management committee? It shall consist of minimum 3 members. 3 members, not directors. Majority of them shall be directors, including at least 1 independent director. What do I mean by that, sir? Remember, people, even a non-director also can become a member of risk management committee. That is very important. In case of listed entity, if you have SR equity shares, at least two-thirds of the committee shall comprise of independent director. The chairperson of RMC shall always be a member of the board. The meeting or quorum, the risk management committee shall at least conduct 2 meetings in a year, and the quorum shall be either 2 or 1/3 of the member, whichever is higher, including always at least one member of the board shall be present. The quorum, sir, this has been now increased from 180 to 210 days. There shall be, the meeting shall be conducted in such a manner on a continuous basis, not more than 210 days shall elapse between 2 consecutive meetings. So we saw here, right, 2 times in a year, the gap between 2 meetings shall not be more than 210 days. Okay, basically what is the role, people? Risk management committee always, risk management committee will take care of any imagine unforeseen events, business continuity plannings, all those things they will be trying to manage it. Okay, what is the role of audit committee? Before that, let us go directly to your, okay, guilds. We'll see guilds. Section 186. What is section 186? Whenever a company makes any loan, any investment, okay, let us do in our order only. If a company is giving any guarantee to someone, if a company is making any investment, if a company is making any loan, if a company is giving any security, section 186 will apply. Now, what if it is making any guarantee, investment, loan, security, sir? In such case, they're telling you, it stipulates that no company shall directly or indirectly give any loan to any person or body corporate, basically more than people. What is the maximum they can give? They cannot give people value of more than 60% of its paid up capital, free reserves and securities premium, or 100% of its free reserves and securities premium, whichever is higher. So what is the maximum guilds we can do? It has to be taken aggregate, everything put together. So my guarantee, investment, loan, security, everything put together should not be more than 60% of its paid up share capital, free reserve, securities premium, or 100% of free reserves and securities premium, whichever is higher. It should not go beyond that. Sir, what if we want to give beyond that? If you want to give beyond that, people, then you need to pass a special resolution. If it is within that limit, people, you need not take shareholders approval. If it is beyond that limit, people, you need to mandatorily take shareholders approval. That is, special resolution is mandatory. Next one, sir, you also have to disclose about this in the financial statements and prior approval of financial institutions. Should I take prior approval of financial institutions? The answer is yes. If at all you have any outstanding loan, but even this condition can be exempted, meaning I need not have to take any prior approval of financial institution. When is that, sir? If at all the prior approval is not required, when is it, people? If at all the total amount that you guys are doing, guilds, if it is not exceeding the limit prescribed. What is the limit? 60% of paid up free reserves securities premium, or your 100%. If it is not exceeding that limit, and I have not made any default in repayment of any of the installments, if both the conditions are satisfied, in such case I can do guilds. Even though I have outstanding loans, I need not have to take any approvals. Remember that. Next one, rate of interest on the loan. Always remember, whatever is the interest you charge, the rate of interest, it shall not be less than, people, whatever is the prevailing interest rate of any government securities closest to your tenure. Meaning, if a government security is there for 3 years, if your loan amount is also 3 years, the minimum interest shall not be less than whatever is the prevalent government yield rate. Yes, however, this condition shall not apply to a Section 8 company in which at least 26% or more paid up capital is held by government, and they are investing that money, they are giving that money as loan for funding industrial research and development projects. In such case, people, this condition will not apply to them. The rate of interest condition will not apply to them. So it can be even less than that as well. Remember this. Disqualification, a company which is in default in repayment of any deposits, they cannot make guilds easy. Maintenance of registers, remember all the entries that you have made, guilds, you have to maintain it in the form MBP2. Yes, and it shall be preserved in the company permanently, and all the entries shall be made within 7 days of making the guilds. Done. Non-applicability. Okay, this is the main point of your guilds. Remember that. Next one, sir. Investments to be held in company's own name. Technically, all the investments you make, people, should always be held in company's own name. If at all, if there is any investments you make, if it is not held in your own name, you need to, what is that? You need to make an entry of all of that in the form MBP3. What is MBP3? All the investments made by the company which are not held in its own name. Remember that. Okay, let us go to the next important ones, that is related party transactions. What do I mean by related party, people? For a company, who and all is considered as related party? Now let us take from the example of Reliance Industries. They're telling you the director and the relative. Director, I'll take Mukesh Ambani. Mukesh Ambani and his wife are considered as relative. Next one, the CS, KMP, CFO, CEO, all of them are considered as related party. Not only them, also their relatives. Who is considered as related party to Reliance? A firm in which director, manager or his relative is a partner. What do I mean by that? For Reliance Industries, who is my director? Mukesh Ambani. Now Mukesh Ambani is also a partner. He is a partner in some partnership firm. They're telling you this partnership firm where my director is also a partner, this is considered as a related party. Next one, a private company in which Mukesh Ambani or Mukesh Ambani's relative is a member or a director. So in a private company, if that private company, in that my director is a shareholder or my director is a director, that private company is also considered as a related party. Next one, sir. A public company in which a director or manager is a director and holds along with his relatives more than 2% of paid up capital. For Reliance Industries, his director Mukesh Ambani along with his wife is a director and a shareholder in one public company. Let us imagine XYZ. In that XYZ, Mukesh Ambani and his wife are holding more than 2% of paid up share capital put together. The public company becomes a related party for me. Next one, any person on whose advice, directions or instructions a director or manager is accustomed to act. If Mukesh Ambani is listening to anyone's direction or advice, people, whoever is controlling Mukesh Ambani, they are considered as related parties. Next one, any body corporate which is a holding company, subsidiary of a holding company and an investment company or a venture company. Basically, people, my subsidiary company, my holding company and my associate company, and there is a company X. I am one subsidiary company. There is another subsidiary company of company X, company B. Any transactions between these two are also considered as related parties. Remember that. Sir, what if it's a related party transactions? Always remember, if it's a related party transactions, you need to mandatorily pass a board resolution. However, if related party transactions, if it is exceeding certain limits, what are the limits? See, these are the related party transaction. If at all you are selling or purchasing or supplying any goods or materials, if the value of which is 10% or more of the turnover of the company, it is not single, it can be one time or all the transactions put together in a year. If it is exceeding 10% or more of the turnover of the company, then people, if it is less than 10%, then people only board resolution is sufficient. If it is 10 or more percentage, people, I need to also pass board resolution plus ordinary resolution. Selling or otherwise disposing of any property, if I am selling or disposing of property, what is the value? 10% or more of the net worth of the company, board plus ordinary. Leasing of property, board plus ordinary. Availing of any services with a related party, the value of which is 10% or more of the turnover of the company, board plus ordinary. Where the transaction or transactions to be entered into as a contract or arrangement is for appointment to any office or place of profit in the company, its subsidiary company or associate company at a monthly remuneration exceeding 2.5 lakh rupees as mentioned in clause F. So imagine you are appointing someone as a director. If they are entitled for more than 2.5 lakh as a remuneration, monthly remuneration, people, you need to take ordinary resolution. What do I mean by that? Imagine Mukesh Ambani's son is appointed as a director to a company. For a monthly remuneration of more than 2.5 lakh, they're telling you cannot do it without taking the shareholders' approval. Where the transaction or transaction to be entered is for remuneration for underwriting the subscription, underwriters. If you are paying them exceeding 1% of the net worth of the company, people, then ordinary resolution is mandatory. However, remember people, whenever we are taking this, I have put everything in one shortcut, remember this. If it is a related party transaction, however, it is your ordinary course of business and in your arm's length transaction, that means, now say for example, there is a company called as, say, Jio. In Jio, there is a director. Now, Jio's director may use Jio SIM card only by paying the required money. That's called as ordinary course. The SIM card is purchased by you, me, and also the director of Jio. Now, should I consider this as a related party transaction? They're telling you no, provided if it is ordinary course, that means everyday business of the company, and it should be at arm's length price. That means your cost and the whatever is a cost at which they have given you the SIM card, it should be the same for what they have given it to the director also. If the cost is same, in such case they're telling you board approval is also not required, shareholder approval is also not required, but however, audit committee approval you need to take. Hello? But remember, if it is not ordinary course or if it is not in the arm's length price, you need to take all the approvals. Remember this. And one more thing you need to remember is that, what is that? If at all there is any related party, no, Mukesh Ambani, he cannot participate while he is voting for that related party transaction. He need to disclose that and he need to walk out. Correct? Hello? Remember that. Okay, no voting by a related member. A member of the company who is related party shall not vote on the resolution. However, this provision shall not apply to a company in which 90% or more members in number, not value, they are all relatives or promoters, or they are all related parties. Then people, of course, you can continue. You just disclose the fact, you can continue. All these the restrictions will not apply. Where any director is interested in any contract or arrangement with the related party, such director shall not be present at the meeting during the discussion, which we already saw. Disclosure in the board's report, you need to disclose all the related party transaction in the form AOC2 in the director's report, along with the director's report. And people, consequences of related party transaction, people, we already seen in the previous chapter. First thing is people, the directors will be disqualified for a period of people 5 years. That is one thing. Next one, more people. Whenever there is any loss that we have suffered and there is a because of related party transaction, we can recover that loss from such employee or such director as the case may be, whatever loss we have suffered. Next one, people, whatever the contracts we have entered, people, remember that will not bind the company, provided if you still, imagine related party transaction happened, we have not taken the approval, you can still make it valid. How? Within, what is that? See, without obtaining the consent of board or general meeting, if you have done the transaction, and if it is not ratified by the board as the case may be by the shareholders, at a meeting within 3 months from the date on which such arrangement was entered and such contract shall be voided by the option of the board of the. What do you mean by this, sir? Remember, people, even on the date of entering into a contract, if I have not yet taken the board approval or the ordinary resolution, it's still okay. Within 3 months, I have to ratify it, meaning enter into a contract, call them, and then take approval. It will still be valid. Yeah. So related party transaction, the next thing that comes is people omnibus approval. What do I mean by omnibus? Okay. Now remember, people, whenever I need to take or whenever I need to do a related party transaction, I need to mandatorily take the approval of the audit committee. So now we will be doing so many related party transactions. Is it possible for me to take an omnibus? I mean, to take the audit committee's approval for every transaction? They're telling you do one thing. If at all the transaction you're doing with the related party, if it is repetitive in nature, then you can save time. How? By applying for something called as omnibus approval. What do I mean by omnibus approval, people? Omnibus approval means an approval where I would be giving an approval for all the transactions put together. So I'll give an approval at once, provided, remember, the omnibus approval. For me to give an omnibus approval, you need to give me a lot of disclosures. I'll be asking you what is the nature of transaction, who are the parties, how frequently this particular thing is going to happen. So I need to disclose all these details. And also I'll clearly say what is the maximum value per transaction. I'll disclose all of this. Sir, what if I'm not able to give you all these details? Then in that case, people, I will still be able to get an omnibus approval. We will still get it. Provided in such case, if you can say that, 1 second. So I can still get the omnibus approval. It will clearly say, see, maximum value of the transactions in aggregate, which is going to happen in a year. The maximum value per transaction we are allowing. Extent and manner of disclosures to be made. Review of such intervals, we will review it basically every year. The transactions which cannot be subject to omnibus approval, everything we will disclose when we are giving you the omnibus approval. Meaning some some transactions cannot come under omnibus approval. So we will disclose all of that. However, people, remember, omnibus approval shall be valid for a period of 1 year. Now, remember, if I am not able to give all the details to the audit committee, they will still give me the omnibus approval, provided the value of transaction per transaction cannot be more than rupees 1 crore. They can still give me an omnibus approval. Clear? Okay, that is my related party transaction. Yes, sir. That's all. So more or less, these are all the important points that you can pick up from this particular chapter. So read this. If you guys want, you can go for a break and come, and we'll finish your next topic. Clear? Hello, people. What's up? Yes, welcome back. I hope your break is done. So now let us start with your next unit, people. That is chapter 16. Now in chapter 16, you can expect two things, people. What? You can expect the board resolutions. I have also uploaded one video, people, how to draft resolutions and things like that. Pay some attention, watch that particular video. In that, I have clearly explained you on how to present your resolutions and as the case may be. Important from your exam point of view. Okay, the next chapter, people, meeting of board and its committees. Here, pay attention from your end on drafting of majorly resolutions. Next one, notices. Next one, they can ask you to draft agenda of a board meeting as the case may be. So these things, try to pay some attention. Okay. So people, first thing, people, board meeting, section 173. What does it say? What is the frequency of board meeting? Board meetings, people. The first board meeting should be conducted within 30 days of incorporation. The subsequent, every year going forward, you need to conduct minimum 4 board meetings in a year in such a way that the maximum gap between 2 board meetings should not exceed 120 days. There is an exception to this rule. In the case of OPC, small company, dormant company, a registered startup, there should be minimum 1 board meeting in each half of the calendar year, and in such a way that the gap between 2 meetings shall not be less than 90 days. So at least there should be a gap of 90 days. The same thing even applies for the Section 8 company as well. At least in every 6 months there should be 1 board meeting, correct? Okay. Class starts only, someone will call. Okay, next one, sir. Sir, notice of board meeting, people, how many days notice should I give? You should give at least not less than 7 days. Remember, people, the difference between the general meeting and here, they have not mentioned a clear days notice and all. So I need not have to exclude the 2 days date of giving. All that rule will not apply here. Generally, it's a good practice to exclude a day of giving the notice. That's generally a good practice. But there is no clear day concept and all mentioned here. Sir, can I give shorter notice? Is it possible? Yes, it's possible. I can even give 1 day notice. Possible, provided what is the condition? At least 1 independent director should be present at the meeting. Sir, what if the independent director had some commitment and the independent director could not attend our meeting? In such a way that, in such case, what to do? If the independent director is not present, then the decision taken in that particular meeting. So conduct a meeting. Whatever is a decision you have taken, circulate that particular decision, meaning the resolution, circulate it to all the directors, and it will be final only if it is ratified at least by 1 independent director. What if the independent director does not agree? Then people, whatever is the resolution you passed on that day, it will be considered as invalid. Sir, I have a doubt. What? In my company, I do not have an independent director at all. Now, how do I conduct a meeting at a shorter notice? Then people, for you, if company does not have an independent director at all, then people circulate it to all your directors. It will be final only after majority of the directors ratify. That's all. Sir, remember, you need to give the notice of a meeting even if the days of the notice is already given in your AOA. You're already conducting your board meeting on a pre-decided dates. Still, people, you need to give the notice of the board meeting, mandatory. What is the quorum of the board meeting, people? The quorum of the board meeting shall be 1/3 of the total number of directors or 2, whichever is higher. Remember, any fractions shall be rounded off as 1. Quorum, people, of, remember, recent amendment, of course, it's been a long time. The top 2000 listed companies, they shall have a quorum of 1/3 or 3, whichever is higher, and also including at least 1 independent director should be present in the meeting. Yeah, so earlier it was 1/3 or 2. Now you can imagine in the 2 it should be 1 independent director also should be present. So it will be 2 plus 1. Any fraction should always be rounded off as 1. Quorum always to be present throughout the meeting. Remember, in case of a Section 8 company, people, the quorum will be 8 members or 25% of the total strength of the board, whichever is less. Subject to at least 2 people should be present in that particular meeting. That should be my quorum. Okay. Sir, when to conduct a meeting, people? Remember, the law says the original meeting can be conducted on any day, but an adjourned meeting cannot be conducted on a national holiday. If you dive deep into this and see, people, there is no logic as such, people. How can I not conduct a meeting on national day if it's an adjourned meeting? An original meeting can conduct on any day. If you ask me, it's a slip over, that's all. Yeah, that means what? My original meeting can be even conducted on a national holiday. The law is silent on it. Remember that. Yeah, if I go as per the words, then that's the answer. Now, if your question is what if it's asked in the exam, sir? This is the answer. Original can be conducted on any day. The adjourned meeting should be conducted on any day except a national holiday. Okay. Sir, interested director. What do I mean by that? When I'm counting the quorum, Imagine if we are passing any resolution in which any director is interested, meaning that is somewhere related to me, or I am getting some benefit out of it. In such case, people, they are telling you, he shall not be present in that particular meeting, and hence he will not be counted for the purpose of quorum for that particular matter. After that matter is done, he can come back. However, there is an exception. This rule shall not apply to the directors of private company. That is, he can participate and he is also counted in the purpose of quorum. However, remember, sir, you are telling if there is an interested director, then he needs to leave the company is what you are saying. I mean, he should not be in that particular board meeting. Sir, what if, imagine we have 8 directors. Now, what is my quorum? Sir, 1/3 or, okay, let us imagine our directors are 9. Sir, what is my quorum? 1/3 or 2, whichever is higher, correct? Sir, 1/3 of 9 is 3. Sir, let us imagine 7 of my directors are interested. In such case, people, if interested directors exceed or equal to 2/3 of number of directors, then the number of non-interested directors not being less than 2, they only will be the quorum. Okay, 2 directors non-interested, no, it's okay. For that matter, those 2 people itself will be the quorum. They can conduct a meeting. I don't know why they have not tested this particular point in a practical way till date. It's a very good point, but they have not tested. Next ones are passing of resolution by circulation, section 175. What does this say, people? They are saying, sir, instead of conducting a board meeting, can we just conduct a meeting just by circulation? That means, imagine by an email, or can I conduct it by post? Is it possible? They are telling you the matters covered in section 179 and rule 8 cannot be passed by circulation. That means what? Section 179 is nothing but, people, power of board. So the entire power, what we saw in our previous chapter, it has to be conducted only in a physically conducted meeting. It cannot be done by circulation. You need to conduct a meeting for that. You have to conduct a meeting for that. Okay. Next one. The resolution, that is draft, shall be circulated to all the directors. Now what happens once we decide that we are discussing this particular matter by circulation, we will circulate the draft resolution for all the directors for them to respond. We can send it by hand, meaning give it with personal, by speed post, by courier, by electronic means. Now, the said resolution must be passed by the majority of the directors to be a valid resolution. So, if there is 9, 5 people agree, then it's a valid resolution. However, remember, 4 people, let us imagine, 5 people responded. Now, can I say the resolution is passed? Answer is no. Why? Because remember, if minimum 1/3 of total number of directors, if they want a physical meeting for this matter, we do not want it to be decided just on a paper. If 1/3 of them demand for a physical meeting, so in this 4 have not yet replied, 3 says no, we want a physical meeting, the company should conduct a physical meeting. The resolution passes through circulation shall be noted and forms part of the subsequent meeting. I need to prepare minutes, no? It shall be forming part of the minutes of the next meeting. So I need to note it. So that is what they are telling you. Clear? Okay. Quorum we did. Phone resolved. People, what if quorum is not present during the given time, people? Of course, the meeting shall be adjourned to the next week, same time, same place. If it's a national holiday, it will be the next day. However, if at all, even in the adjourned meeting, people, even if in the adjourned meeting, if no quorum is present, then meeting will stand dissolved. Then the meeting will come to an end. Remember that. So next one, the chairman may, unless dissented to or objected by the majority of directors present at a meeting at which a quorum is present, adjourn the meeting for any reason at any stage of the meeting. Very important. What is that? What? Does the chairman, can a chairman adjourn a meeting arbitrarily? Imagine a duly constituted meeting. The quorum is present. Can a chair and adjourn a meeting at his own discretion? Answer is no. If it is objected people, no, you cannot. Yeah. Quorum should be present throughout. Place of vacant. An interest in case of private company, it's 1/3. Meaning of 174. Meeting of committees, same thing. You need to follow the same thing. Committee also. In case of equality of votes, what will happen, people? You will always have second or casting vote. Correct? Meeting of committees, that is your audit committee, nomination, remuneration committee, what is it telling you? A committee may elect a chairman of its meeting. What if a chairman is not present within 5 minutes? Then whoever are the other members, they can elect one amongst themselves to be the chairman. The meeting adjournment, a committee may meet and adjourn as it thinks fit, because I told you, company law, it says it's your choice. If at all there is a equality of vote, the chairman will have a casting vote, also called as second vote. Sir, all acts done by any meeting of the board or a committee shall, notwithstanding that it may afterwards discover that there was some defect in the appointment of any one or more editor, whatever they have done, it will still deemed to be valid. What do I mean by that, sir? Imagine, people, we have conducted a board meeting. All of us agreed for a particular resolution. Later we got to know one of the director was not properly appointed. It will still not invalidate the resolutions passed. The resolution will still be considered as valid. That is what is given here. The attendance registers of the board meeting shall be preserved for a period of 3 years. And if it is in the form of loose leaf form, if you are maintaining it in the paper form, you need to bind it periodically. The periodically will be 3 years. The attendance register is open for inspection by the directors. This is very, very important. What is that? An attendance register can be checked by any director. Yes, any director. Sir, what if there is an attendance register of 2017 to 18? There was one director, he left. Now he wants to come and check whatever is attendance register of 2017 and 18. Can he check? Answer is yes. Even after a person ceases to be a director, he shall be entitled to inspect the attendance register of the meeting held during the period of his directorship, not everything. I hope this is clear. Next one. Sir, what about the directors participating through electronic means, video conferencing? Is it possible? Yes, a director can participate through video conferencing. Of course. Sir, now who will sign the attendance register on behalf of the person attending through video conferencing? Remember, it shall be signed by a company secretary. Sir, what if there is no company secretary? Then, people, it shall be signed by the chairperson. Sir, what if the chairperson is also not available? Then, people, it shall be signed by any other director present at the meeting if authorized by a chairperson. And the fact that participation is also recorded in the minutes, meaning if chairperson authorizes any other person present in the meeting, that is the board, he can go and sign on behalf of that person, and provided this fact also should be mentioned in that particular register. And remember, the attendance register should be preserved for a period of 8 years. Leave of absence will be given to those directors who are unable to attend the meeting. Remember, if you are not attending the meeting for a period of 12 months, you will be treated as disqualified. The chairman of the meeting, we saw. Minutes, people. Generally, whatever we have seen in general meeting, the same will hold good because it is section same, no? 118. I would have also told you there only about the signing of the minutes also. So, nothing to worry there. Chairman of this meeting or the chairman of the next meeting, passing of resolution by circulation. Okay. Duties of company secretary at the meeting, during the meeting, after the meeting. Before the meeting, notices. During the meeting, help with quorum, take all the declarations, help the chairman if at all any legal work required. MBP ones collect all the declarations given. Independence, if any directors are giving you independence declaration on their independence, collect it. After people will be all the any forms to be filed, file it with ROC, prepare the minutes, enter the minutes in the minutes book, finalize everything as the case may be. That's your minutes. Virtual meetings, people. What is virtual meetings, da? You wanted a virtual meetings, huh? Huh? Okay. There is nothing much here, people. Secretarial standards. What is SS1, SS2? SS1 is people basically secretarial standards of board meeting, and SS2 is secretarial standards of general meeting. Generally, in general, secretarial standards is not applicable to OPC and Section 8 company. But Section 8 company, a few parts of secretarial standards will be applicable with regards to the board meeting. That is what they're telling you. Sir, is OPC, do they have to follow SS1? If you have only one director, then no. If you have more than one director, then yes. That's all. Yes, people, that's all is your, board meeting. I hope main points we were able to cover. That's all. That's nothing much in this with particular minutes of the board. Yeah. Yes, people, let's start our next chapter, chapter 17. Sir, CSR is not there, so sir, people remember the notification says CSR chapter is removed, but some concepts of CSR has been now moved to the board report. That is your annual report concept, chapter 18. So even though this chapter is not there, people, under annual report, certain topics are still retained. Now I'm just giving those people a heads up. What are the topics that are retained? Now remember, people, these are the topics which you guys still need to read under CSR. But yes, if it's not so, okay, introduction, leave it. It's okay. You don't need this introduction. Done. Applicability, it's still there. Now come, we see what is applicability. When is CSR applicable? CSR is applicable for every company. This is very, very important. If you are having a net worth of rupees 500 crore, if you are having a net worth of rupees 500 crore or more, or if you are having a turnover of rupees 1000 crore or more, or if you are having a net profit of rupees 5 crore or more in the immediate preceding financial year, then for this year, people, the CSR and the CSR committee will become applicable to you. Yes. Now, sir, I need to keep on checking this condition every year. So imagine, if last year it was applicable, this year I need to spend. Next year, if it is not applicable, then the year next to it, I need not have to comply with the CSR committee or the provisions. So, sir, end of the day, every company who satisfies this particular limit, they need to mandatorily form a CSR committee. As sir, answer is yes, provided one company need not have to form a CSR committee. Since who? If a company ceases to meet the requirement for this is not there, this is an amendment, they have removed it. Now you need to check this particular condition every year. Okay, next one. Amount to be spent. If my CSR expenditure, you remember you used to calculate 2% is your CSR expenditure. You remember? We used to calculate that 2%, this whole part is removed. CSR expenditure is removed. But this part is there. So if your CSR expenditure, the amount you need to spend, if it is coming to people up to 50 lakh rupees, if it is not exceeding 50 lakh rupees, then people, you need not have to form a CSR committee. Then the board of directors only can take that particular role. It is there. Now this is there. Remember. Okay, what else is this? Next one, people. My CSR committee composition is still there. Which company, various company, it is still there. So the composition of CSR committee, people, and one more thing, applicability. Every company, you're a holding company, subsidiary company, you're a foreign company, whichever company you are, for you CSR is applicable. Remember. Composition. The committee shall consist of 3 or more directors, in which at least one shall be a independent director. Sir, if I am a private company, the independent director provision itself will not apply to me. Then okay, you can constitute your CSR committee with only 2 directors. That's fine. Sir, what if I am a foreign company? There are people in the foreign company also. They are telling what? A CSR shall comprise of at least 2 persons and one shall be an Indian resident. That's all. You will not have other provisions. So 2 people, in that one shall be an Indian resident. We do not emphasize on whether you are a director or nothing. And remember, the board's report shall clearly disclose the CSR committee. Now this is there. Remember and go. Next one, activity is not considered as CSR. It is still there. And what are the activities considered as CSR? It is there. Now, 1 second, wait. Okay. Now, see. What I'm telling you, activities which is not considered as CSR, activities in the normal course of business, activities outside India is not a CSR. Political contributions cannot be considered as CSR. Activities, if it is benefiting only the employees, it is not a CSR. Any sponsorship activities where you are getting a direct marketing, if you are just doing it for the marketing, it is not a CSR. Fulfillment of any statutory obligations, like for example air pollution, for that if you are just recycling the water pollution, recycling the water, it is not a CSR. Any charitable contribution, TV shows, advertisements, all these are not considered as CSR. So then what is considered as CSR? If you remember people, schedule 7, that is still there. The big list, it is still there. So remember and go. Your eradication of hunger, employment, or your what is that? Old age homes, slum development, rural sports development, adoption of villages, all those things are still considered as CSR. Har Ghar Tiranga, Azadi Ka Amrit Mahotsav, all these are still considered as CSR. That is still there in our syllabus. Remember and go. Schedule 7. Sir, what else is there? Unspent CSR account has been removed. You need not have to study this. Sir, non-compliances penalties have been removed. You need not have to study this. CSR reporting, people, it is not completely removed. Initially, they said that it is removed. Now, this part is there. Website disclosure is there. Impact assessment is there. But they have removed the heading called CSR reporting. So, technically, if you ask me, CSR reporting is still there. So, what is CSR reporting? Every year, people, the board's report, it is mandatorily in the board's report. You have to tell what is your CSR committee and what are the activities you are carrying on. Everything has to be mentioned in your board's report. Website disclosure, you need to clearly disclose on your website the composition of CSR committee and CSR policy and all the projects that are approved. Impact assessment, people, what is impact assessment? Once you start carrying on a CSR project, you need to also tell how is that particular project being beneficial for the people there. So people, the companies with average CSR obligation of rupees 10 crore or more in the last 3 financial years. So in my last 3 financial years, the average CSR expenditure has to be 10 crore or more. Then people, impact assessment report will be applicable to me. If it is applicable, then what should I do? I have to contact one independent agency. I need to call them and I need to ask, can you please come and check whether my particular project, is it helping the public there or not? What will they do? They will come and carry on an impact assessment. So should I carry on impact assessment for everything? Now, for example, a company like Reliance and all, they carry on 40, 50 projects. Should I carry on an impact assessment for all the 40, 50 projects? People, not required. You need to carry on the impact assessment, people, only for those projects where the spending of the money is at least 1 crore or more. If you have spent on any project, people, let us imagine I have carried on 5 projects. On one project, I spent 50 lakh. Another project 2 crore. Another project 1 crore. Another project like this, it is going on 20 lakh. Wherever I have spent, people, 1 crore or more, then people, I need to carry on an impact assessment. Meaning how many people are getting benefited. Imagine if I have constructed an hospital, how many people are visiting, who are the patients, what are the different ailments that has happened, everything I need to report. For 50 lakh not required, 20 lakh not required. Sir, when should I start the impact assessment? I just constructed a hospital this year. Should I carry on the impact assessment immediately? No, people. You need not have to carry on the impact assessment in its first year. So whichever is the project which is at least 1 year old, only for those projects you will conduct an impact assessment. Remember that. Sir, impact assessment expenditure can be booked. Now I need to pay for the independent agency. They will not do it free of cost. How much can I pay? You can pay up to whatever money you want, you pay. But can I show it as a CSR expenditure? Answer is yes. Up to 2% of my CSR expenditure. You take whatever is my CSR expenditure. In that 2% you can take up as independent agencies ka salary or 50 lakh rupees, whichever is higher. I can show it as people CSR expenditure. Remember that. Is this clear, all of you? Okay, this is there. And what else is there? If I look at it, see this national awards, all this is removed. Here they say impact assessment is removed, but I told you indirectly it is still there. What else is there? This is there, people. CSR implementation is there. That's the last part. Remember that and go. Implementation of CSR. How do I carry on my CSR implementation, sir? Remember, the board of company may decide to undertake CSR activities approved by the CSR committee through. I can carry it on, people, through how? A company established by. I can carry it on by Section 8 company, or I can do it by registered public trust, or I can do it by registered society. Correct? Which is registered under Section 12A and which is also approved under Section 80G of IT Act. Sir, now who has established this? This is established by the company, whether alone or together with any other company. That is, imagine Infosys itself has formed a foundation called as Infosys Foundation, or Infosys and Reliance together form one foundation. That is also possible. This was earlier, people. Now what did they do? Section 8 company, trust or society, which is registered under Section 12A and 80G. This was the only thing. Now people, they have also added one more thing. What is this? The one more thing is whether you are registered under Section 12A and 80G, or I can add one more thing. If you are exempted under, if you are a Section 8 company, if you are a trust or if you are a society who is exempted under, people, Section 10 clause 23C subclause 4, 5, 6 and 6A. If you are exempted under this section of Income Tax Act, technically, people, these are nothing but your, if you remember, I would have given you in your syllabus also, they are educational institutions, hospitals, or any other institutions. They are the people who are exempted under this section. So you can be either Section 8 company, trust to society who is exempted, who is registered under 12A and 80G, or exempted under Section 10, 23, say 4 to 6A. Now people, these people, whether you are, it is situated, it is registered by the company, or Same thing. A company established, same thing, but established by someone else, not Infosys. Someone else is doing. So can I donate the money to some other Section 8 company, trust or society which is registered under same thing, 12A or 80G or Section 10 exempted by some other company? I can give, provided they should have an established track record of at least 3 years. I can do it. So one is my company, one is someone else establishing it. Next one, people, a company which is established by same thing, Section 8 company, trust or society which is established by central government or state government. So if the government is establishing it, people, you can even give the money to them. The fourth one, people, any other entity established under Act of Parliament or state legislature. So if it's a statutory company, you can give the money to them. So technically, you can implement CSR in 4 ways. One, if it's a company which is established by you, or if it's singly or together with other company, and if it is registered under 12A and 80J or exempted under 1023C 4566A or established by someone else having a track record of establishment of 3 years, or a Section 8 or trust or society which is registered by central government or state government, or it's a statutory company, I can implement my CSR through them. Yes, so these are the topics that are retained in CSR, people. Yeah, these are the topics that are retained in CSR. That's why I'm just keeping the CSR as still CSR only. But this cut copy paste has been moved to annual report. So now that CSR reporting is there, no impact assessment and all of that has to be given along with your annual report. So remember this. Clear, Ram? Yes, Ram. So now we'll go back to your annual report, that is chapter 18. Yes, people, welcome back. So we are left with the last 2 chapters, chapter 18, the annual reports, and chapter 19, KMP. Technically, yes, as per your syllabus, leaving your inspection, CSR and all, of course, reduce 2 chapters from this. Okay, now what is annual report, people? Okay, now people, there are certain disclosures which are to be made by a company in various places and to various people. Now what are the disclosures that can be called as? The disclosures can be called as, people, one is called annual report, which is majorly applicable for listed companies. Board report, which is applicable for every company irrespective of whether listed, unlisted, small, big, anything. And annual return. These 2 can be ignored. We can concentrate on these 3. Now what is that? The first one is called as annual report. Now what do you mean by annual report? It is a report provided by public companies to disclose their corporate activities over the past year to evaluate the firm's performance. In short, if I have to tell you, people, it is nothing but a summary of all the activities that have happened in a particular company. In the last financial year, we put everything in one place and we prepare something called as a summary. Now that is only called as what, people? An annual report. Annual report will have lot of things in it. Now what and all will be there in an annual report, people? The annual report will have, see, as per SEBI LODR, listed companies shall submit annual report to stock exchange, on the website, and also to the shareholders. What will annual report have? It shall contain the details of audited financial statements of the company, consolidated financial statements of the company, subsidiary and associate companies, and certain additional information. What is that we will see? It will also have cash flow statements. It will also have director's report. It will also have business responsibility report. This is what it is applicable for the top 1000 listed companies only, not every company. What will be there in the business responsibility report? The BRR will just have, people, what are the initiatives that the company has taken towards sustainability, towards environment. If I have to tell you in short, people, nothing but, for example, reduction of using plastic or using more and more renewable resources, solar dependency. So these are all called as what, people? Initiatives that the company has taken towards responsibility as a company. Now, sir, the next one is, sir, certain additional information we need to disclose, it seems. What is that? One is, people, related party disclosure, management discussion and analysis, corporate governance, and, people, demat suspend account or unclaimed suspense account. So what we will do, we'll have to learn about these things. Now what does it say? Now see here, now annual report. Under that, whatever I tell you is important, try to see. They've asked this once. You need to disclose people in your annual report about your related party companies. Now, what I need to disclose, related party disclosures, first in the holding company, what should I disclose? I need to disclose the amounts at the year end and the maximum amount of loan advance investments outstanding during the year. So, a holding company needs to clearly disclose what are the roles and loans and advances that the company has made in subsidiary company, the loans and advances that the company has made in associate company, the loans and advances that the company has made in any partnership firm or any company in which my directors are interested. If you remember in our previous chapter, we saw our related party transaction. So in that we saw where our who and all are related parties. So if at all we have made any loans or advances, we need to give all those details here. Not only that, the same thing applies even in a subsidiary company. We have to give the details that we got it from the holding company. The same thing, sir, in a holding company, investments by the loanee, in the loanee means what people? The company who has taken loan. In the shares of parent company and subsidiary company, when the company has made a loan or advance in the nature of loan, what I have to say, investments by the loanee in the shares of the parent company and subsidiary company when the company has made a loan or advance. What do you mean by that, people? If you remember section 19, can a subsidiary company invest in the holding company? If it all it has invested, we need to disclose. There are some exceptions, right? You need to disclose that. And disclosure of transactions of a listed entity. Let us imagine Infosys with any person or entity. Imagine we have done a contract with XYZ Limited belonging to the promoter or promoter group, Infosys promoter group. Let us imagine Narayan Murthy, which holds 10% or more shareholding in XYZ Limited. So if Narayan Murthy holds 10% or more shareholding in XYZ Limited, then people, you need to give such transactions also. Any disclosures or anything that we have made, transactions with XYZ Limited, we need to disclose that also under related party transaction. Done. Next one, sir, under management discussion and analysis, what should I give? Directly come to this point, which is important. You need to give the details of significant changes. What do I mean by significant changes? That is, when the change of 25% or more as compared to my previous year, if at all it has happened in any of my debtors turnover ratio, my inventory turnover, interest coverage, debt equity, net profit margin. Simple. Debtor turnover means what, people? Imagine today if something is my debtor, someone is my debtor. Now when will this person make the payment? Imagine he takes some 20 days. Now 20 days is my debtor turnover ratio. But for the next year, people, this 20 days has become 15 days. If you look at it, the change is 25%. It has reduced by 25% of days. Now people, I need to disclose this under debtor turnover ratio as significant changes. Same thing, inventory. What is the inventory turnover? How many days is it taking for your raw material to convert into stock into sales? You need to see, imagine if it is taking around 30 days. Now in the next year it is 35 days. Nothing predominant has changed. So you leave it. It's okay. Ignore. So like that, you need to do it for everything. Done. And you need to also disclose the accounting treatment as per accounting standards. Next one, sir, corporate governance report, people. In this, nothing but you will disclose everything about the board of directors, like what is the attendance, what is the number of meetings conducted, where and all it was conducted, and independent directors were there. Are they still independent? Disclosures received from independent directors, the directors' composition, everything I will disclose under the board of directors column under my corporate governance. What else I'll disclose? I'll disclose about all my committees: audit committee, nomination remuneration committee, stakeholder relationship committee, risk management committee, entire thing, their details, their composition, who is a chairperson. I'll write everything here. See, example can be see risk management committee, their composition, stakeholder, their composition, NRC, their composition. So you will disclose everything in the particular thing, people. And what else I'll disclose? I'll also disclose people POSH. What is POSH? Prevention of sexual harassment. What are the total complaints received during the year? How many did we resolve? How many did we carry forward to the next quarter? Everything I will disclose. Next one, declaration signed by the CEO stating that the board of directors and senior management have confirmed the compliance with code of conduct of board of directors and senior management. Whatever the code of conduct we have for the directors and the senior management, how should they act? The CEO certifies that our board and our senior management are acting as per that. Compliance certificate from either the auditors or practicing company secretary regarding the compliance of conditions of corporate governance shall be annexed. What do you mean by that? All these committees and all, the diversification of board, all the committees, related party transaction, all of this we have complied. They're telling you, you need to get a certificate from the auditors of our company or practicing company secretary. Either of them will have to certify, and that certificate I have to also attach with my director's report. Remember. Next details, sir, that will be there in my annual report is disclosure with respect to demat suspend account or unclaimed suspense account. What is this, people? Let us imagine if there has been any shares which no one has claimed, then what will the company do? The company will transfer such shares into an account called as demat suspense account or an unclaimed suspense account. Now, in that, what will I do? See, in a year, I will transfer all the shares to demat suspense account or unclaimed suspense account. Now, here I will tell during the year how many shares were transferred, how many shares were reclaimed by people. So all the details you will get. See, aggregate number of shares and outstanding shares in the account in the beginning of the year. Number of shares who approached for the transfer, who took it back. Number of shareholders to whom shares were transferred. How many approached to how many we gave. Aggregate number of shareholders and their outstanding shares in the suspense account lighting at the end of the year. Opening balance, closing balance. That the voting rights on these shares shall remain frozen. Remember, people, as long as the shares are in this account, on those shares there will be no voting rights. Done. Next one, people, board's report. In board's report, people, certain things are important. Directly go to those certain things. What is that? Director responsibility statement. You need to give your director responsibility statement, people, for 6 aspects. What is that? During the year, this is section 134 subsection 5. Easy to remember. Remember, section 1345. Director responsibility statement is nothing but, people, during the year, the company's directors were responsible enough to make sure they have applied all the applicable accounting standards. So as if there is any material departure, we will also mention about the material departure of the company. Next one, we have followed such accounting policies which will help us give you a true and fair view of the state of affairs of the company. So accounting standards, accounting policies. The third one, people, the directors had taken proper sufficient care to maintain adequate accounting records. So books of accounts, all of that we are maintaining properly, no problem, nothing to worry. Next one, whatever our annual accounts are, we are maintaining it on a going concern basis. That is opening balance, closing balance. Closing balance of this year becomes opening balance of next year. Next one, in our company we have sufficient internal financial controls. That is, we have sufficient internal financial controls so that there are very less amount of chances for a fraud to take place. Next one, the directors had devised proper systems to ensure compliance with provisions of all applicable laws, and the systems were adequate and operating effectively. That means what, people? We have any mechanism in the company so that there are so many laws applicable to the company. We are complying with all the laws. We have not done any non-compliance. That's all. Next one, CA. What is CA, people? Next, nothing but, people, section 143 subsection 12 talks about reporting of fraud. Whenever the amount involved in the fraud is less than 1 crore, in such case what will happen? The auditor will report nature of fraud, what is the parties involved in the fraud, what is the amount involved in the fraud. The directors have to give a reply to it in their director's report, mentioning all three plus what was the remedial action you took. You need to mention it in your director's report. Next, directly go to the amount of dividend distribution, conservation of energy, Sir, material changes and commitments, if any, affecting the financial position of the company which have occurred between the end of financial of the company to which the financial statements relate and the date of the report. What do I mean by that, sir? Sir, let us imagine our financial year is 2026 and 31st March 2027. Now, when we prepare our audit report, financial statements, director's report, we always prepare it for this year. But when will we prepare it? We technically would have prepared it in the month of say 30th August 2027. So before AGM we prepare. For the year 26-27 we prepare it in the month of August 27. Now you tell me, in between April to August, from 1st April 27 to this day, there can be further things, some material things that could have happened in a company. A new loan could have been taken, new charges might be created. They're telling you, even after closure of financial year, if at all there is any commitment or changes that the company has taken place which will significantly affect the financial position of the company needs to report that fact also in the board's report for this duration as well. That is what is this important exam point of view, remember. You need to give your reply to whatever we saw, 143, for all the audit reports, any qualification, reservation, observation reported by cost auditor, secretarial auditor or statutory auditor, you need to reply to all those observations. And you have to disclose all the details with regards to equity or DVR, that is you satisfied all the conditions. Sweat equity, you satisfied all the conditions. ESOP, so I'm again not going there again. Voluntary revision or disclose CSR, composition detail of vigil mechanism, disclose pertaining revenue. People 197.12 will again go and will be doing it in the next chapter. We'll see what is that. Sexual harassment, again it is repeating. What is that? The Act mandates that all companies having 10 workers or more shall disclose in the annual report the details about what? Sexual harassment, that is the number of complaints during the year, the number of complaints disposed, whatever we saw, correct? Same thing. And the statement that the company has, why is it repeated so many times? You can ignore this. I'll also give the details of the disclosures of IEPF, that is how much of money have we, how much amount of unclaimed or unpaid dividend and the corresponding shares that we have transferred to IEPF. Redemption amount of preference shares, amount of mature deposits, amount of debentures, application money, whatever we have sent it to IEPF, we'll write the details. And year-wise amount of unpaid or unclaimed dividend is unpaid up to the year of corresponding shares which are liable to be transferred to IEPF. Meaning we have started transferring the shares from 2016 till 2026. How many did we transfer? Give the details of everything year-wise. The amount of donation, if any, given by the company, above donation, that is from your own pocket. Who will give? But if you are giving, I need to disclose. Annual return we will do. Secretarial auditor, IEPF fund. Okay, this again is repeated. Okay, we need to check it again. I need to reclassify everything. Okay, next one we will credit rating of securities according to SS4, Secretarial Standards 4. As a good governance practice, that is basic on your report, board's report. The disclosure on credit rating should also be included in the board's report. You get a credit rating, no, that should also be disclosed in the board's report itself. What I have to disclose? Credit rating obtained in respect of various securities, for all securities. From whom did you get it? Date on which the credit rating was obtained, which date? Whether has it been revised? In the 24 I got it, in the 26 the same rating stands like this. Reasons provided by the rating agency for a downward revision. In the 24 we got it. We were A grade, in 26 we are in B grade. What are the reasons provided? You have to disclose all of this in my credit rating, remember. So should I get it for everything? You will get it for everything, people. You will get it for equity, debenture, imagine deposits you have. Deposits chapter also you would have studied, no. So I have to disclose this every year, remember that. Signing of board's report, very important. Who will sign the board's report? If at all a chairman is authorized by the board, then only the chairperson will sign. Where the chairperson is not authorized by the board, in such case, at least 2 directors shall sign it. In that 2 directors, 1 director shall be a managing director if appointed. Yes. Okay. Procedure, board report. Okay. Annual return. Directly go to annual return. Oh, we did everything from this only. Yeah. Okay. Annual return people directly come boards report annual return. Okay. What about it has to be filed compulsorily every year with ROC. It is a non-financial matters disclosure. We disclose only non-financial matters here. When should we file annual return? You have to file it within 60 days from the date of AGM. In which format is it filed? It is filed in a format MGT7. However, if you are a OPC, small company or a startup, you will be filing it in the form OPC or small company, you will be filing it in the form MGT 7A. Sir, if you're a foreign company, the format is people FC4. Okay, it shall be preserved for a period of 8 years. Sir, what if a company does not conduct its annual AGM? Then you need to file it within 60 days of due date of AGM along with the reasons of why you did not conduct your AGM. And it shall be signed by, if it is a small company and OPC, it shall be signed by one director and by a CS. If there is no CS people, then by a director. PCS signature is not required. Of course, same thing applies for a startup company also, a private company which is a startup. In case of other companies, the signing of the annual return will be done by director and CS. What if CS is not there? Then it shall be signed by PCS. Next one, annual return of a listed company or a company having paid up capital of 10 crore or more or turnover of 50 crore or more. Remember, your annual return should be additionally certified by a practicing company secretary. That format of that additional certification will be in the format MG8. What is the difference between annual return and this one, people? Because here also CS is signing. Then why do we need additional PCS signing it? Remember, people, MGT7 might have been prepared by a company secretary who is in the employment. Now, what he would have done, now let us imagine, register of members is maintained by the CS only. Now, he is only making the entries in the annual return also. So, if you look at it, it's like you are only writing the exam, you are only checking it. So, if a company grows big, we want an additional evaluator to come and check. That is what is happening here in the format MGT8. He will come and tell whatever details that you guys have mentioned in your annual return, everything is accurate. I have checked it with the corresponding records, reports, minutes, forms, documents, registers. Everything he will check and he will verify and he will sign that yes, the company has satisfied all the documents, all the information, everything is properly there. Sir, what is the penalty, sir? If a company does not file annual returns, people, what is the penalty? Minimum will be people 10,000 and for every continuing date of default, you need to pay 100 rupees per day, which can go up to maximum of 2 lakh rupees for the company. 50,000 rupees for every officer in default. That is a penalty for the failure to file annual returns on time. Yes, sir, that is my annual return. Yes, sir. Okay, I think most important aspects, I think we have done. Yes, people. Let's go to the last chapter, people. Last chapter is, people, KMP, the most easiest for you all. Yes, sir. Let us concentrate as much as possible, people, for your KMP sections. Clear? Okay, yes, people. Now, what do you mean by KMP? Of course, we have a definition of what do you mean by KMP. Who is a KMP, people? After going around the world, we are coming for the definition of KMP. Who is considered as KMP? Who is considered as KMP? CEO, CFO, Managing Director, Manager, Whole-Time Director, CS, and one level, not more than one level below the board is considered as what? KMP. Agreed? Okay, fair enough. Now, what are they saying, people? Should every company appoint a KMP? They're telling you, As according to section 203 and read with rule 8, every company shall have a full-time KMP. Who are the full-time KMP? A company which is a public company having a paid up capital of 10 crore or more should have a mandatory managing director or CEO or manager, in their absence a whole-time director, and CS and CEO, they should be mandatorily appointed. If your paid up capital is people 10 crore or more in the case of public company, in the case of listed company, it is mandatory. So what about private company? Private company, as per rule 8A, if your paid up capital is 10 crore or more, you need to have a mandatory full-time company secretary appointed in your company. That is section 203 done. Now go to next case. That next case is nothing but, sir, key points on KMP. What is that? One person can be a KMP of maximum one company. However, sir, let us imagine there is a holding company. In that, I am a CS. In a subsidiary company, can I also be a CS? Yes. The answer is people. Answer is yes. That is what is given here. You can be a KMP of more than one company, provided that company is your subsidiary company. Allowed. KMP can be a director in other company, prior permission of the board is required. Meaning, sir, I am a CS in my company. Can I be a director in other company? Possible, provided people your board has to agree for it. Agreed. Next one. Can a person be a MD of two companies? Yes, possible. Maximum two companies, not beyond that. Provided appointment is approved by all the directors in a meeting. So whenever you are being appointed as a director in another company, now such approval first has to be consented by all your directors, and not even one vote you have to get against. So remember, vacancy in a KMP is always filled by the board. This is very important. Remember, appointment of KMP and reappointment both are done by people, the board of directors only. Yes. Next one, return of appointment people, form MR1 within 60 days of appointment. Of course, if you are a managing director, your appointment has to be also confirmed by shareholders. Whenever you appoint a KMP, you need to intimate people to ROC about such appointment in the form MR1. So these are some special points about your KMP. Now, sir, directly going to the appointment of KMP. Can we appoint? Yes. How? I need to follow section 196, read with schedule 5, which speaks about appointment, which is read with part 1. Now what does it say? Whenever you want to appoint a managing director, whole-time director and manager, then what are the conditions you need to satisfy? First one, the company shall not appoint a managing director and manager at the same time. Why, people? Because of conflict of interest. Both of them have a substantial interest in the company, so you cannot have both, because both cannot have highest power in the company. Then there will be a conflict. The tenure of these people shall be maximum 5 years. Can I reappoint them? Absolutely fine. There is nothing called cool off period and all. But the reappointment people cannot happen prior to 1 year of his expiry. So 4 years is done. Another 1 year is pending. Now you can reappoint. You cannot reappoint in the 3rd year only. That is not possible. Disqualification to be appointed as a MD, WTD manager when if at all you are below 21-year-old, that is if you are not 21-year-old, or people if you have attained 70 years old. In such case, people, I cannot appoint you as a managing director. However, there is one exception. What is that? People, let us remember, people, if you are 70-year-old, can I appoint you? Yes. Beyond 70, can I appoint you? The moment you are 70, you have to discharge, you have to disclose. I mean, you'll have to resign. But can I still continue his appointment? Yes, possible. How? You need to pass board resolution and you need to pass special resolution. Beyond 70 years, you can still appoint. Sir, what if I did not get special resolution? Then what did you get? Sir, I got ordinary resolution. Then okay. If at all you managed to get ordinary resolution, then do one thing, pass board plus pass ordinary, plus you need to take central government approval, then you can still appoint a person who is more than 70-year-old on your company. Allowed. Sir, at any given point of time you have been adjudged as an insolvent, you cannot be an MD. Anytime if you have suspended any payment to the creditors or you have went and compromised with them, you cannot become a MD. Anytime if you have been convicted of an offense and if you have been imprisoned for more than 6 months, less than 6 months not disqualified, more than 6 months people, then they are telling you, you will not be appointed as a managing director. And sir, subject to the provision, appointment, now what is this? Sir, I told you that you need to take the approval of central government. How will I take the approval of central government? I'll take the approval of central government in the form MR2. That's the form I'll file. Yeah. And what are all the forms that you file, people, when you are appointing a managing director? Always remember, when I'm appointing a managing director, I need to file these forms. According to section 117, whenever an MD is appointed, you need to mandatorily file form MGT 14. And managing director is also a director, hence I'll also file the form DIR 12. Managing director is also a KMP, hence I need to file form MR1. If at all I need to take the approval of central government, I need to file form MR2. Remember this, very important. Okay. Next one, additional conditions prescribed in Schedule 5 of Part 1. What is this, people? Always remember, in Companies Act 2013, there has been one schedule which is clearly given. When you want to appoint a managing director, there are two parts, people. One is called as Part 1, which speaks about appointment condition. Part 2 speaks about remuneration conditions. Now, what does that say? Now, see, there is Schedule 5. We have something called Part 1, Part 2. This Part 2 has been further classified into this 5 schedules. 5 sections. What does it say here? Part 1, conditions to be fulfilled for the appointment of a managing director without the approval of central government. Without approval, how to appoint? Yeah, so you should have not done any of this disqualification. If you are disqualified, then you need to take central government approval. Next one, Part 2, which speaks about remuneration. What is it? We will see when it comes. Okay. Now see, what does it say? You should have not been sentenced to imprisonment even for 1 day. Or you should have not been coming under fine exceeding 100,000 rupees under 19 acts. All your act is there, people. Your SEBI, Competition Commission of India, FEMA, every act is there. So even if you have made to pay a fine of any amount more than 1,000, so 1,001 rupees if you have been set to pay, then people, they are telling you that you are disqualified to become a managing director. So you cannot do it without central government's approval. Next one. If you have detained for any period, people, even 1 day, under conservation of foreign exchange and prevention of smuggling activities, coffee posa, even for 1 day, if you are arrested, people, you cannot go for a managing director appointment. You should be a resident of India, and people, this condition will not apply to SCZ. Now that is my 196. If I satisfy these conditions, sir, and remember, what is it? If appointment of managing director, whole time director, manager, if it is not approved by the company in general meeting, any act done before such approval should not be deemed invalid. What do I mean by that? See, first the managing director, because he is a KMP, he will be appointed by the board. But only if you are a managing director, your approval will your appointment should also be approved by the general meeting, by the shareholders. Now imagine we appointed but they rejected. But for this general meeting to happen, let us imagine we took 1 month or 2 months. In the 2 months, whatever activities you did, it will still be binding on the company. That activities will not become invalid. Possible exam question, remember and go. Now people, let us come to the overall maximum managerial remuneration paid to the employees. That is your managing director. How much, sir? Now that is given, people, in section 197. Now what is the maximum overall remuneration that we can pay, people? The maximum overall remuneration that we can pay depends upon whether we have profits or we don't have profits. Now let us imagine in our company we had enough profits during the year. We had money. We don't have any problem. If you have money, people, then what is the maximum remuneration you can pay? See, first, the director is entitled. For the managing director, manager, whole-time director, they are telling you the maximum remuneration we can pay, people, all the employees put together, I cannot pay more than 11% of the net profits of the company for that financial year. Everyone put together. So the maximum managerial remuneration we can pay when we have profits, all the directors put together, executive and non-executive, everyone put together cannot be more than 11%. Sir, what if I want to pay more than 11%? Take shareholders approval. Sir, this is for all. What about one managing director, one whole-time director, one manager? Each of them can be paid up to maximum 5%, not beyond that. Sir, what if I want to pay? Pass special resolution, shareholders approval. So this is for one. So what if I have more than one managing director? So if I have one managing director and three whole-time directors, everyone put together cannot be more than 10%. That means what? If one director got 5%, the rest of the directors, everyone put together, you guys have to distribute 5%. So this will be probably for 3 people. Are you getting the point? Okay. Sir, I want to pay more than 10%, same thing, special resolution. Next one. So what if I am not a whole-time director, managing director or manager? That means what? I am a non-executive director. Sir, in that case, how much will I get? They're telling you people, directors who are neither managing director nor whole-time director, then they're telling you, I will get 1% of the net profit of the company if we have a MD, whole-time director, manager. So the maximum we can pay is people 1% to the non-executive director. Sir, what if I want to pay more than that? Special resolution. Sir, what if we do not have, where there are no managing directors, whole-time directors or managers, there is no one. In such case, how much you will pay? You will pay us 3%. Is it per person or sir? 3% is everyone put together. That's the maximum we pay. Is this clear, all of you? Yeah. This also, directors who are neither, for them 1%, here it is 3%. I hope it is clear now. If I have to put everything in together, people, all the directors put together, I can put it like this. Executive director plus non-executive director will be 1%. If a company only has non-executive directors, everyone put together is 3%. If a company has executive directors only, the maximum you can pay is 10%. One executive director can be paid up to 5%. If a company has executive director and non-executive director, then everyone put together is 11%. But the bifurcation will be executive will take 10%, non-executive will take 1%. I hope this entire chain is clear. I can pay more than this provided I take special resolution. Done. Sir, this is when we have profits. What if we don't have profits? Whenever you don't have profits, people, then what we will do? See, now this is when we will go to this chart. See, remuneration payable by the company is having profits. This is what is given in section 1. Now, what if I don't have profits? If I don't have profits, people, I will pay as per section 2. Now, section 2 also is further classified into 2 parts. One is called as limit A, one is called as limit B. What is it? I'll tell you. Yeah. Now, when we don't have profits, what is the maximum remuneration I can pay you, people? The maximum remuneration I can pay you depends on my effective capital. What is effective capital? Effective capital, just pause for a while. This is the, the formula for finding out my effective capital. So once you calculate this, you will get effective capital. Once I have my effective capital, now what is the maximum remuneration I can give? It depends upon who you are. Are you an executive director or a non-executive director? If you are an executive director, you will come here. If you are a non-executive director, you will come here. So when I don't have profits, then what is the maximum remuneration I can give? They're telling you, if my effective capital is negative or less than 5 crores, less than, that is 4.9999. In such case, the maximum I can give per year, per person is 60 lakh rupees. Per year, per person. Sir, what if I am a non-executive director? If you are a non-executive director, then we will pay up to 12 lakh rupees. Next one, sir, 5 crore to 100 crore, 84 lakh, 17 lakh. 100 crore to 250 crore, 120 lakh and 24 lakh. Everything is here. 250 crore and above. They're telling you 120 lakh plus. So for the first 250 crore, you will give 120 lakh plus 0.01% of the effective capital in excess of 250 crore. That means what, people? Imagine our effective capital is coming to 300 crore. For first 250 crore, it is 120 lakh. For the rest of the 50 crore, I will calculate 0.01%. Whatever comes, that will be my total remuneration I can pay to the directors. Sir, can I pay more than what is given here? Of course. Only condition is pass special resolution. That's all. Done? Yes. Sir, what if it's part of the year? If it is part of the year, take it pro rata. That means what? 60 lakh is for year. If it is per month, do divided by 12. What is the number you get? That is the number. Next one, sir. Sir, now you just said this is limit A. Okay, we limit A. So I hope you are understanding, people. Schedule 5 first has total 4 parts. Part 1 speaks about appointment. Part 2 speaks about remuneration. Part 2 are further classified into 5 sections. In that 5 sections, section 1 speaks about whenever you have remuneration, what is the maximum you can pay. That is 11 or 10 or 1 or 3 and all. Section 2 speaks about people when you do not have you do not have profits, what is the maximum remuneration you can give. Now that depends on people whether is it coming under limit A, limit B. Limit A is for your regular directors. Limit B are those directors who are appointed in a professional capacity, meaning they can be your doctors or they can be, imagine a company secretary. For his experience, he's been appointed as a director. Now for them, can we pay this salary? Is it allowed? Can we do it? They are telling you, people, you can pay them. It is allowed. How much can we pay them, sir? Remember, limit B does not again tell a new limit. Limit B says if at all he is a managerial person working in a professional capacity, then you can pay them remuneration as per limit A, provided they need to satisfy certain conditions. Now, what are the conditions that the person has to satisfy? The condition that the person has to satisfy is, now what is that? Okay, what does it say? See here, the managerial person functioning in the professional capacity, the remuneration can be paid as per limit A. When if that person is not having any interest in the capital of the company, holding subsidiary company, that means what, sir? Now imagine I have elected a person A to be paid as remuneration as per limit A. Now can I pay him? Yes, it's you can pay, provided what? He should not have any shareholding in our company. Sir, what if he has ESOPs? Okay, ESOPs are there up to 0.5% of the shareholding I will exempt. If he is having 1% not people, no, he is disqualified. He cannot come under this particular limit. Now, point 2. He is not having any interest or related to the directors or promoters of the company holding subsidiary during the last 2 years or after the date of appointment. You should not be related to any of my company or subsidiary or holding directors or promoters. You should not be related. So you should be a random outside person. Next one, you should have a graduate level at least qualification, because I'm paying you in professional capacity. Not only that, people, whichever is the industry that you are working in. Let us imagine if I'm working in the industry of, I don't know, now I'm a doctor. Specialized knowledge, meaning I can say I should have MBBS there. Specialized knowledge. If all these conditions are satisfied, I can pay that person under the professional capacity. I can pay as per the limit A. Clear? But remember, end of the day, whether you want to pay as per limit A or you want to pay as per limit B, you need to satisfy certain conditions or approvals. What is it, people? To pay a person as per limit A or B, such things has to be first approved by people, the board of directors and the nomination remuneration committee. The company has not committed any default in payment to the bank, PFI or non-convertible debentures or secured creditors. If at all there is any default, you need to take prior approval. What do you mean by that? For any financial institutions, you should have not committed any default. Say, you have not given the loans back, and if you are giving them salaries more, who would accept that? So to give such salaries, people, you need to take prior approval. Next one, people, to pay anyone as per limit A, you need to pass ordinary resolution. Sir, if I have to pay anyone as per limit B, you need to pass special resolution. Remember that. That means a person working in professional capacity, mandatorily requires a special resolution, and such resolution will be valid for a period not exceeding 3 years. Next one, all the details about such person should be disclosed in my explanatory statement. Calling them for a meeting. Shareholders I'll be calling. No, I have to disclose all these details. Remember and go. The next one, people, let us take section 3. What is section 3? Now go here. Remuneration payable by companies having no profit or inadequate profit in certain special circumstances. What do I mean by that? Again, here also there is no profit. Here also there is no profit. But still you can pay remuneration, it seems. Even when you do not have profits. You can still pay. When? Certain special scenarios. What are special scenarios? First one, such excess remuneration is paid by some other company, not my company. Which is that some other company? It can be a foreign company or it can be any other company, provided such a company has taken its shareholders' approval in general meeting, and that company has to treat this as a managerial remuneration as per their section 197. Sir, we didn't understand. Imagine, people, there is company A, company B. Can I have my director being appointed in my subsidiary company also? Possible? No. KMP can be a KMP in the subsidiary company. Possible. You can be an MD in 2 companies. Possible. Now imagine the salary is given to you by A, not B. Allowed. So if you are not, so if company B is in losses, it's okay. You pay. Company A can pay, provided they're telling you, now they have to treat this in their overall managerial remuneration of section 197. 11% limit and all, they should treat it. Allowed. Understood? Okay, next one. Sir, in the case of newly incorporated company, up to 7 years of the date of incorporation, if not, no one will join you. Allowed. In the case of sick companies, today's date, this and this will not exist anymore, people. But these were nothing but companies who are struggling to exist. Sir, if they are struggling to exist, then why are you allowing to pay directors' remuneration? Don't pay them. People, if they don't, if they are not there, then who will work for you? Who will make your company revive? So they should be there. You find ways to pay them, that's all. That is what they are telling you. So for a period of 5 years from the date of sanction, but today SIG company and BIFR and all almost does not exist. Today what exists? NCLT, IBC plan will exist. So if a company has been approved by a resolution plan, so under a insolvency and bankruptcy code, you can pay them, people, up to 5 years allowed. Is this clear? In addition to that, to pay the excess remuneration as mentioned above, remember, except in the case a managerial person should not be receiving remuneration in any other company, only in one company you have to be receiving, that is from here to here. This is an exception. The auditor or a CS or a PCS should certify that all the creditors and the lenders have given the approval for such payment. It should be filed in the form MR1. They shall also certify that there is no default on payment of creditors and deposit holders. So there is absolutely no default, we have to certify. Is this clear, all of you? Okay. Now go to section 197. What does appointment say? Let us see that section completely. Okay, 197.1, when you have profits, that percentages we saw. Okay, next one, 197.2, remuneration does not include sitting fees. Remember, whatever is the overall remuneration, that does not include sitting fee. What is the maximum sitting fees you can pay? The maximum sitting fees, people, cannot exceed 1 lakh per meeting. Next one, 197.3, in case of absence or inadequacy of profits, what to do? We just saw. That is a limit we are seeing as per Schedule 5 and Part 2, Section 2. Correct? Next one, sir, 197.4. We saw sitting fees is not included in the remuneration. No, what else is not included? Where is the insurance? Go to the insurance part. Any premium paid on the insurance. Remember, people, for the directors, people, we generally take D&O insurance, no? whatever is a premium paid, company will generally take the insurance. So they're telling you the premium amount will not be calculated in the director's salary. That is on the head of company only, it seems, provided if any director is caught, whatever is the insurance paid by the company on behalf of the director, that will also form part of their remuneration. Until you are not guilty, then it will not form part of your remuneration. So remember this and sitting fees. Next one, sir. Sitting fees we saw 1 lakh per board meeting. Remember, independent director, women director also should be given sitting fees. Mode of payment of remuneration, you can give it monthly as percentage of net profits, partly by both are allowed. Sir, if such director is paid excess remuneration without approval, can we pay? If you have paid by mistake, remember, such a director should hold it on behalf of the company in trust, and you need to repay such excess paid within 2 years time. Yeah, maximum is 2 years. Until such money is refunded, you need to hold that entire money in trust. Sir, what if we don't want to refund? He is not agreeing. Then can we waive it off? They're telling you people, the waiver of excess money, it is possible provided you pass a special resolution. So, if I have to connect one more point here, people, section 180, subsection 1, clause D. If at all you want to waive off any excess remuneration paid to the directors, you can waive off, provided you cannot do it only by a board approval. You need to also pass a special resolution that is required. Remember this. And remember, if at all you have taken any loans, and if you have made any defaults in the loans, people, remember you also have to take the approval from your banks, PFIs, creditors, as the case may be. 197.12, what does it say? Disclosure in your board's report. Whatever we saw in our previous chapter, we also have to disclose about our majorly people, our top paid remuneration employees. And has the company been wise enough when you are giving remuneration to your employees? That means what? Now imagine, people, in my company there are 100 employees. Arrange them in a lower to higher order in terms of salary. Imagine we have a employee who is getting 10,000 and we have an employee who is getting 5 lakh per month. Arrange them in the lower to higher number, ascending order. Now whoever is the mid, now let us imagine we have the 50th sum. Now what you need to do, you take the mid salary, that is only called as what people, median remuneration. You need to give a comparison in your board's report. How much has our 50th employee salary increased, and how much has our managerial directors, our managerial person, how much has their salary increased? Give it in percentages, give a comparison, you give, that is something which you need to give, so that the shareholders understand when they are reading, has the company directors working wise, or their salaries are increasing 20% but their salaries are increasing 2%. Especially you would know, whenever there is a hike season and all. That is what they are telling you. See, the ratio of remuneration of each director to median remuneration, you have to give a comparison ratio. Percentage increase in the director, CEO, CFO, CS and the median person. Comparison of percentage increase. How much this increased, how much this increased. Board reports shall also include the names of top 10 employees in terms of remuneration who, if you are employed throughout the year, if you are getting a remuneration of 1 crore 2 lakhs, remember not 20, 1.02 per year. Sir, what if I am not employed throughout the year? Then do divide it by 12. That is 8.5 lakh per month. If you are getting that salary, I need to disclose the details about such a employee. What you need to disclose? You will disclose all the designation, what are they doing, what was their previous employment, are they getting any shares also? I disclose everything. What else I disclose? Who drawn remuneration excess of that drawn by MD holds along with spouse not less than 2% of the shares of the company. What do you mean by that? I'll also disclose the details about those employees who are drawing salaries more than managing director, whole-time director, manager, and people. They are also shareholders of at least 2% in that company. They have shares. Allah, along with the relatives. You need to disclose the details of such particular employees also. Clear? Okay. penalty, leave it, it's okay. And one more thing what we need to do is, let us do the section 202. Compensation for loss of office. What is compensation for loss of office? First we'll do a 199. Where is 199? What is 199, people? Whenever in a company, if at all, let us imagine, there is something called as restatement of financials, no? My is not coming, search is not working, array, no. Okay, recovery of managerial remuneration in certain cases. Let us imagine, people, according to section 130 and section 131, what is this? Restatement of financial statements either by the order of the authorities or voluntarily. What happened, people? In the year 24-25, we have paid our directors. Imagine one executive director was paid 5% of the average profits of the company. Now, in the year 2028, people, we got to know that in 24-25, we had inflated our financial statements. So, our profits were showing more number than what it was supposed to show. Now, what happened? We have given our executive director 5% on the inflated profits. Now, when it is revised, this will also go down, no? Now we have paid extra. What to do? They're telling you, you can recover that extra amount. Absolutely possible. That is what they're telling you. That is section 199C. This section provides for recovery of remuneration, including stock options, if any, where the amount is given in excess and the refund is happening because of restated financial statements. Is this clear? That's all. So you can take a refund of it. So next one, sir, compensation for loss of office, section 202. Let us do of that one particular section. Section 202. So I'm just taking all the important aspects instead of just dumping. See, they have given the role of company secretary and all that you guys can manage. But this and all, at least it is good for you to at least revise once. Okay, compensation for loss of office, people. This condition is only and only applicable to a managing director, whole-time director, manager. What if I remove a company secretary? Will he get a compensation for loss of office? No. Will any other director, non-executive director, will he get? Answer is no. That is one place where they can question you. Next one, people. Compensation shall not be paid in the following cases. When the director resigns due to reconstruction or amalgamation, what happened, people? Imagine Vodafone Idea came together. The Vodafone Idea, the new entity, offered a role to you, but you denied. That is your headache. We offered you. So we have not removed. So I will not be entitled to give you any compensation. Next one. When director resigns from his office, you resigned. Why will I give? He is vacated as per 167. Disqualification. Because of that you are removing. Why we should we give a compensation? Company is being wound up, and that too because of your negligence only. Why should we give? Director has been guilty of fraud or breach of trust or negligence or mismanagement in conduct of affairs of the company holding subsidiary. Basically, people, you have done fraud. Who will give the compensation to you? Director has instigated in termination of his office. Any other purpose, people, but the reason why you are leaving is because of your action, not because of mine. In such case, I am eligible to get a quantum of compensation. How much will I get, people? First, you need to counter for how long I have been appointed. I am appointed for 5 years. Okay. How many years is done? Let us imagine 1 year is done. 4 more years is there. Okay. What is the compensation I'll get? I'll get for 4 years or 3 years, people. Whichever is less. So I'll get compensation for 3 years. Okay, how much will I get? You will always get, people, your 3 years, last 3 years average salary multiplied by whatever is the duration. That means what, sir? Let us imagine, sir, I have completed 3 years. What is my remainder? 2 years. 2 or 3, whichever is less. Which is less? 2. For you have already completed 3 years remuneration. Take average. So that 3 years average multiplied by 2 years. That is what is the remuneration you are going to get. Next one, no compensation shall be paid. The company goes into winding up. 12 months before or after the date of director ceases to hold office. That means, people, if the company itself is going to winding up people before or after, once you leave the company, why will we give compensation? We are only under a loss. Yeah. So this is your main essential thing under your audit and all. I think we did it there only in the past. So these are the main things, people, that you guys need to know with regards to KMP. So I believe with this we have completed whatever is the maximum in detail marathon I can do. I have done, people. Now the ball is in your court. Please make use of it, and the only thing that matters is whether it helped, and whether you're able to achieve what you guys want to achieve because of that. Do let me know if you guys want any additional help. Whatever is possible, I'll at least try, but I would know what you guys in specifically want. So do keep me informed on that. You can comment, you can let me know. I'll be more than happy to help you in those regards. Yeah. So, yep. Thank you so much. See you all. Wishing you guys the best. Let the best happen to you always. If you guys clear, do find a way to reach us out. Do let me know whether you are my student, you're not my student. A positive result will always put a good smile on us. Yeah. So we would also be that first people to celebrate your result along with your loved ones. So thank you so much. See you all, people. Bye bye. Take care.